Hello, is that Danella?
Yes, it is, yeah. So
Oh.
I'll be clerking this afternoon's hearing.
Yeah, and you're doing tomorrow afternoon too.
Yes, that's correct. Yeah.
Fantastic.
Would you like me to let you know in the chat who the next submitter is and the name of the submitter? And whether they're submitting in person or on Zoom?
No, that's all right. I think unless there's any indiscrepancies, then we'll just carry on with what the revised agenda tells us.
Okay, great.
I think
the first submitter isn't here online yet.
Okay, that's being Lexi Matheson.
Yeah, but we do have Jane Logie.
Okay, well, we can swap them around at 1 o'clock.
Okay.
If Jan's happy for that, if Lexi's still not there.
Okay, fantastic.
We'll give it 30 seconds.
Doing a good job, Chair.
Oh, thank you, Mr. Deputy. Oh, I went out for a walk. The temperature's dropped.
Where are these guys?
Okay.
Auckland.
Right, members. Okay, we'll make a start. Members, welcome back to Finance and Expenditure hearings on the Regulatory Standards Bill Day 3 in the afternoon. We'll be going till 5 o'clock at the latest by the look of it. Thank you for all your cooperation in this morning, and I'm sure we will continue to run like a bath of oil this afternoon. Now, we haven't got Lexi Matheson queued up yet, I don't think. Have we, Clark?
We've got Jane Logie here.
But we've got our former parliamentarian and colleague, Jan Logie, queued up. So welcome, Jan. There we go. Oh, we've just got you on
Kia ora koutou.
Oh, very good. Oh, well, you need no introduction or any guidance on this. We look forward to your 5 minutes, Jan. Thank you in advance.
Thank you. And thanks to the committee for this opportunity to submit today. It's a bit strange being on this side, but bear with me. So first up, to be really clear, I oppose the Regulatory Standards Bill in process and content. And today I want to focus on one key point and then address some of the rationales that I've heard in support of the bill. So the first point I want to make is around social cohesion. And I note that last year, New Zealand replicated an Australian survey to measure social cohesion in the country, and it found that 49% of New Zealanders agreed with positive statements that indicate social cohesion. In Australia, comparable questions gave a higher score at 56%. New Zealand's social cohesion is 8 percentage points lower than in Australia at the moment. And New Zealand lagged on every single dimension in that survey compared to our Australian friends, who we've always traditionally liked to think were less cohesive or progressive than us. The measures that were focused on in that survey were a sense of belonging, a sense of worth, social inclusion and justice, participation, acceptance, and rejection. And I really just want to re-echo one of the comments in that survey, that without social cohesion, societies become increasingly unstable, from politics to business to civil society to day-to-day life in our communities. And we're seeing this pattern all around the world, but New Zealand has been significantly impacted. Now, some of you may ask, why is this relevant to this bill? Well, I think it is relevant because, as I see it, the role of MPs, part of the foundation of our democracy, is, as members of Parliament, you are there as representatives to balance and consider the complex range of interests in our country, from those of the people in our local communities to different interest groups to different lobby groups. And there are broad and many often conflicting interests and value systems in our community. And democracy, the heart of the idea to me, is to be surfacing those and to be contesting those ideas so that people see themselves represented. Even if their ideas don't win out in that contest, that they know that there is a link and a point of understanding of their reality in the decision making. Now, my concern with this bill is that it privileges one set of values that are not universal values. And often, particularly if you look at individual rights, can be understood at times to be directly in conflict with collective rights. And where there is no mention within this at all of Te Tiriti as our founding document, that absence doesn't provide a pathway for the members of our communities to feel as if they are being understood in the normal run of business of our parliament. And I cannot see how that can have anything but a detrimental impact on social cohesion. And I believe very strongly that it is the role of every single member of parliament at this time in our history to be focusing on building social cohesion, ensuring that diverse voices are heard and are included and values are included in the process. And I want to mention that, so there's an understanding that this hasn't happened and isn't represented in the context of the content of the bill, but also I want to call out the process of the development of this bill. I was involved in one of the submissions to MB on the consultation that was probably discarded before the decision was made at Cabinet. And the sense of my views and those that I was putting forward at that time, being excluded from that process has an impact. It told us that actually our view didn't matter. And I think that it should be of a concern to every member around that table. And I also, that the minister's media and dismissal of the opposition to this bill is being caused by bots and those misinformed, that undermines social cohesion. We have to be able to listen to different views and give them the respect that they deserve, even if we disagree. And that is not happened in this process, and I think that is also reflected in the content of the bill. And I just very briefly, my time may be up, so I may not get to my other points, but I believe that the structure of this also creates confusion with overlap in other structures of decision-making in government through the Legislative Design and Advisory Committee, Regs Review, the regulatory impact statements, the role of Treasury and the Ministry of Regulation. It creates more confusion, and where it says it's meant to be driving towards consistency, there remains a legal obligation to be consistent with Te Tiriti or Waitangi, and yet that is absent from this. So in fact, it very clearly by design removes the ability to have consistency in process in the development of legislation. So it's deeply problematic, and I do not in any way support this bill.
Okay, thank you, Jan. You are at time, but given your 4 terms in Parliament and your legislative achievements, I want to give Deborah Russell a question.
Jan, I'm very much in support of what you say. I get the feeling, though, that the proponents of this bill would say that they'd take your words and say, well, you're not giving us the respect and listening to us and including us in the conversation. How would you respond to that?
Been listening very carefully. And there's also the power of the state that really needs to be understood in this, right? Where was it 99.6% of the submissions to MB opposed this? I think I've given much more than 0.4% of my time to considering the arguments of those who support this bill.
Yeah, thank you.
Okay. Thanks again, Jan. Lovely to see you. And thank you for submitting. Thank you for
Everyone.
appearing before us, and all the best for the rest of the day.
Thank you. Thanks, everyone.
Thank you. Okay. Clark, have we got Lexi Matheson online?
No, not yet, but we have Raymond Horan from Taituara.
Okay. Let's get Raymond through then. Thank you.
Here I am.
Oh, Raymond, there we go. Just if you can introduce, I'm sure you're a familiar face to many, but if you can just introduce yourself and your organisation, and we look forward to your 5 minutes, or your 10 minutes at least.
Thank you, Mr. Chairman. Kia ora te te mana mēna me mau te committee. Ko Raymond Horan tōku ingoa, hei Chief Advisor o I Taituara, hei mihi mai e te kotahi mana o ngā mema o Taituara me te whānau ngā konahira o Aotearoa. I'm Raymond Horan, Chief Advisor with Taituara, the membership body for local government professionals and staff. I bring greetings from the 1,000 members of Taituara and the wider local government family. Thanks for the opportunity to submit on the Regulatory Standards Bill. As one of our core businesses, if you like, is helping local authorities prepare good regulations. So we are always interested in steps that our counterparts in central government are taking to promote quality regulation. In the time I have with you this afternoon, I want to leave you with 4 points that are perhaps a bit more specific to our submission than and you may not have encountered in some of the others. I think point number one, the bill needs to expressly exclude local government from its coverage. As the bill stands, it's arguable whether or not the secondary legislation we make is covered in this particular bill. So when I talk about our secondary legislation, I primarily mean bylaws. The point I want to make today is we consider good regulation essential, and that in making those regulations, our bylaws, local government is actually held to a higher standard even than is apparent in this bill. Members, you can ask me to expand on that further if you wish. And by the way, that standard is justiciable. Courts can and do overrule bylaws all the time. And again, I can provide you some examples of that if you wish. Our second point is around implementation. The bill needs to ensure that ministers and officials are proactively planning for implementation needs in the regulations that they make as they're making them. Implementation should be planned alongside the development of regulations with the regulated sector. And our recommendation 5 provides you with some words that you might serve as a starting point. Similarly, effective regulatory stewardship should be better incorporated into the principles. Treasury's quite right when it says regulations need to be managed as an asset, which means periodic preventive maintenance. We've given you an example of a local government relevant piece of legislation that hasn't been looked at since 1981, and the disincentives that particular piece of legislation can provide. It's an example of just the lack of legislative maintenance. Try saying that 5 times quickly. And my fourth point, the engagement principles in the bill are adequate, and it was nice to see them there. They need a bit more by way of support, and we did go backwards and forwards on whether that was something for legislation or practice. And in the end, at the bottom of page 11 of our submission, we set out what we think should be happening, which is that Cabinet papers should spell out what engagement has been undertaken. They list what government departments have been engaged with. They don't, and they do generally say, and we have engaged with such and such in the sector. They don't usually, however, go on and say what feedback might have been received. gold standard some of the cabinet papers that were done during the review of the Local Government Act. Back in 2002, there were comments, Local Government New Zealand as the representative of the sector was cited as having been consulted. There were a couple of lines that were put in that highlighted the key feedback LGNZ had given on each of those issues. Those are my 4 points. I would just conclude by saying 2 things. One, we have followed submissions closely and would generally agree with what has been said about treaty principles. We likewise would agree with what our colleagues in Te Uru Kaheka have said about the so-called regulatory takings principle. And then I would just like to conclude my opening statement by reminding the committee we have access to a network of 78 councils, 1,000-ish members, and thousands of years of collective experience with regulation. Our 2-person policy team, we've got 70 years experience alone. And we make that available to the committee to assist them as it considers that bill. And in that spirit, members of the committee, I'd like to take your questions.
Oh, thank you very much, Raymond. We've got a question here from Marama Davidson.
Raymond, thank you very much. Oh, sorry. Firstly, can I be heard? Can
Yes.
people hear? Thank you.
It'll be
Great.
fine.
Thank you. Great. Could you please expand? There were some examples that you were willing to offer, and particularly in relation to your recommendation about scope and that this bill does not extend to the local government sector. Could you give us an example from the ground on how you see that playing out? Thank you.
Okay, so I can talk a little bit firstly about the higher standard that we're invited to meet. So in making a bylaw, Local Government Act, and this is common to bylaws across most but not all pieces of legislation, when we're making a bylaw, we have to demonstrate, firstly, that a bylaw is the best means of resolving a particular issue. Secondly, that the form of bylaw we've chosen to make, or are proposing to make, I should say, is the most appropriate form of bylaw. Thirdly, and as you'd expect, bylaws can't be inconsistent with the Bill of Rights. They can, and that's generally read as interpreted as they can't be, among other things, they can't be unduly vague in their effect. They can't be disproportionate to the size of the problem. The member asked for an example. I'll give one. It's a little dated, but it is high profile. And it was the issues that the former Auckland City Council had. Long and the short, there was an annual adult entertainment expo that was kicked off with a parade of topless women down Queen Street. Auckland Council tried to ban toplessness across the whole city, the entire area of the whole city. The promoter challenged that, or sought injunctive relief to stop the council from making it. The learned judge looked at that. They said, well, according to the law of New Zealand, public toplessness is not prima facie illegal. So the council needs to meet a higher standard here. We believe that in this case, banning it throughout the whole city is inappropriate. I'm prepared to grant the injunction. The parade went ahead, council abandoned it. That's one very high profile example.
Thank you. Okay, that looks like it's a wrap. We've got to the 10 minutes. Thank you, Raymond, again for your submission and your work and your representation of professionals in local government. And we look forward to another interaction with you, no doubt, again sometime.
Kia ora.
Thank you for appearing before us.
Thank you.
Thank you. Clark, have we got Ngapuhi iwi social services?
No, we don't have them online yet. I know that Lexi is having some trouble coming online. but we don't have any submitters here in the room either at the moment.
Okay, so should we just take a pause for 3 minutes and check back in at 1:21, team? How are we getting on, Danella? Have we got anyone queued up?
Yeah, we've got Ngapuhi here now.
Okay, well, just members, if we can get back on screen, and when we've got most of you on board, we'll introduce Ngapuhi. Very good. Okay. So welcome. I think we've got Moana there. Or we might need your video on.
Kia ora.
Oh, kia ora. Welcome. Thank you for your patience. You've got 10 minutes with us. Thank you for appearing before us. We look forward to it. So please proceed. Thank you.
Kia ora, kia koutou katoa. I am Moana Iruira. I'm the Chief Executive Officer of Ngapuhi Iwi Social Services. We take our submission as read. We firmly oppose the Regulatory Standards Bill. It is an overreach in power and will harm descendants of Ngapuhi. It should be removed from the legislative agenda. I lead a medium-sized iwi social service in Kaikohe as part of Te Runanga a Iwi o Ngapuhi. We all want our tamariki and whānau to be safe, secure, connected to whakapapa. So do all the families that we work with, but unfortunately they have challenges and circumstances that make it extremely difficult. Every day we see that struggle. We see the harm that they bear and the trauma that they carry, and this bill will make that worse. I take my role really seriously, and part of that role is advocacy with and for those that we work with. In the past year, I have taken time to write and do oral submissions 4 times, as the damage and systemic impacts of these bills on our whānau o Ngapuhi is too high to ignore. They will cause harm to tamariki and whānau that we work with. We have represented on the repeal of Section 7AA, the Treaty Principles Bill, the Serious Youth Offending Amendment, and now the Regulatory Standards Bill. We should be putting all of that time and effort into that work. It's serious work. But here I am again today. And I did really have to think seriously about whether or not I should come, because it doesn't appear that our submissions are taken seriously. NIS envisages a future where Ngapuhi whānau experience healing and intergenerational oranga. We are strongly connected to whakapapa, fulfilling our dreams and aspirations and expressing rangatiratanga. NIS strongly objects the bill's deliberate omission to any reference of Te Tiriti o Waitangi in its regulatory principles. It implies that Te Tiriti commitments are optional rather than foundational. Ngapuhi remain unsettled as an iwi, with many of our rights and aspirations embedded in legislation where iwi and hapu are explicitly mentioned. The proposed bill threatens to strip those protections away. This will adversely affect the well-being of our Ngapuhi tai tamariki and whānau that we at Ngapuhi Iwi Social Services support. We have the highest numbers of tai tamariki Māori in state care and at risk of engaging with the Crown system. As at February 28th, 2025, 751 Ngapuhi mokopuna are engaged in the care and protection system in Aotearoa. 30% of all tamariki in care in Tāmaki Makaurau are Ngapuhi or affiliated to Ngapuhi. At least 10% of our total Ngapuhi population, 12,387, are in the cohort of tamariki and rangatahi who have been identified as having early risk factors leading to engagement with the Crown care and youth justice system. NIS, or Ngapuhi Iwi Social Services, continues to work tirelessly in a challenging political environment to reduce disparities, improve inequities, and enhance whānau well-being. However, meaningful progress will be difficult without proper recognition of the Crown's obligations and commitments to Te Tiriti o Waitangi. The bill's emphasis on formal equality, including the sub-principle that every person is equal before the law, intentionally works against iwi-specific provisions designed to address long-standing disparities for iwi, hapu and whānau. The Waitangi Tribunal warned that this could lead to a regulatory constitution that systemically reviews and dismantles legislation that supports Māori well-being. At Ngapuhi Iwi Social Services, that's our core business, making sure that tamariki and whānau well-being is cared for. The Waitangi Tribunal also found that the Crown proceeded with the bill's drafting and cabinet approval without any targeted engagement with Māori, despite consistent advice from officials urging early and genuine engagement with iwi and hapu. This is unacceptable given the bill's constitutional significance. This exclusion reinforces a pattern of marginalisation and undermines our right to exercise tino rangatiratanga and decision-making that affects the futures of tai tamariki, whānau and hapu. The Tribunal rightly found this to be a breach of principles of both partnership and active protection. For Ngapuhi Iwi Social Services, we are community-facing and work every day to uphold the well-being of our Ngapuhi tai tamariki, whānau and hapu. This bill threatens to weaken the legal and moral obligations that compel Crown agencies to engage with iwi. Without robust treaty safeguards, future regulation under this bill would further entrench inequities, undermine our rangatiratanga and erode the fragile trust that still exists. The well-being of our tai tamariki and whānau will not be sacrificed for the benefit of regulatory convenience.
Documents on the table there.
Okay, very good. We've got a couple of hands up here. We'll go with Mr. Ferris first.
Tēnā koe mana.
Kia ora.
He whai pānga nui e nei kōrero ki au, te me he tamariki he moko puna nā Ngapuhi aku tamariki.
Ai.
So yeah, just for my colleagues, these things are very important to me because my children are descendants of Ngapuhi. And right across the country, we have iwi social services in particular. So here, Ngapuhi iwi social services, doing the best we can in concert with the government, you know, under less than ideal circumstances to begin with. Then you have, like you say, the 4 different bills you've had to submit against in the last year, sucking up your time. And here we are facing one of probably the most significant and long-lasting ones as a proposal. So my question to you, Moan, is, you know, what are the simple, I suppose, impact effects of this particular bill limiting or hindering your ability as Ngapuhi iwi services to deliver on those outcomes that you already commit with the government to delivering? So what are the limiting impacts that this new one, the RSB, has put in front of you?
One of the principles I think underpinning the bill, which talks to everybody is the same. And so at Ngapuhi iwi social services, you know, I've talked about the highest numbers of tamariki and care, and that's for our iwi. It doesn't matter whether you look at it by iwi or by needs, we're still the highest. So, you know, the inequity issue is really important. And in the past, we've advocated for tamariki and mokopuna who whakapapa te Ngapuhi. But we work also with everybody. But if you're thinking about care, you know, our tamariki are the highest in care. So we put the small resource that we have into our Ngapuhi specific tamariki. If we had more resource, we may be able to work with everybody, but actually we've got a huge job just working with the tamariki that we have. So the assumption that one size fits all, that we should go for equality, that we should all have to use the same approaches, and that regulation will require us to do so, is of real concern, and limiting and puts up barriers and doesn't allow us to work towards the reduction of inequities. So there's a lot of barriers there, Takuta.
Yeah, thanks, Takuta. We're going to go to Marama Davidson.
Thank you, Mr. Chair, and kia ora moana and kia ora Ngapuhi. In acknowledging the work that Ngapuhi and others are doing every single day to keep our whānau tamariki mokopuna safe, you have spoken about the RSB getting in the way of true equity. You actually have sort of answered my question already to Takuta and his Ngapuhi children. But would you like to give the panel, the public, an example of the positive mahi you are doing to address those disparities that you've talked about, of the stuff that's working on the ground, as a way of identifying what this RSB would get in the way of? Kia ora.
Kia ora, Marama, what a lovely question.
That is a great question. We're just a little bit short of time, so I just invite you to give us a succinct answer as possible, with respect.
Fine. Okay, so I think in the youth offending area, and I know that's one of the government's targets, but it's also one of our very high priorities here at Ngapuhi iwi Social Services. We run a remand home for tamariki who have offended, they're on remand, and they come to us, and we work with connecting them to their whakapapa, pro-social behaviours, work with an individualised therapeutic plan so that they don't reoffend. So that's one small example. There's many, many more.
Oh, very good. Okay, well, that brings us to time beautifully. So thank you, members, and thank you, Moana, for that presentation. Thank you for your submission. Thank you for your time this afternoon, and enjoy the rest of the day.
Kia ora.
Kia ora. Okay, Danella, have we got Tertiary Education Union?
Yes, we do. Sandra Gray.
Okay. Okay, Sandra Gray, welcome. You've got 10 minutes. We look forward to your presentation. Leave us a little bit at the end so members can ask questions if they want to. Thank you.
Thank you. Kia ora tātou ngā mihi nui, ko taupiri te maunga, ko waiku mei Waikato te awa, ko te hautu kaharangi e mahi ana. I am the National Secretary of the Tertiary Education Union, a union with around 11,000 members from across New Zealand, Kaitaia to Invercargill, in the universities Wānanga and in the polytechnic system as well as PTEs. Our membership is urging this committee to terminate this bill. We are doing so because we think it poses major risks to our democracy, to our constitutional integrity, and to public accountability mechanisms. Like many of the submitters you would have heard before, we also are objecting to the changes that are proposed in this legislation because of the absence of the Te Tiriti o Waitangi as one of our founding documents and a necessary part of any constitutional and regulatory system. You will have heard from many of our members about both this matter, Te Tiriti, and about the next statement, which is because we have members who are experts in constitutional law and political science, and my history is in political science. So the last point I want to make is that this bill is problematic because if passed, a very narrow set of values will be used to judge whether legislation regulation is actually good legislation. And it is not a simple case when you are, as you will know as politicians, it's not a simple case when you're evaluating the value of a piece of legislation or regulation to say this ideological perspective of libertarianism and privatisation, private ownership is the best one by which to judge legislation. That then discounts a whole lot of other values that we as a movement, that we as a democratic union value. We as a democratic organisation have to consider both individual and collective rights at the same time and always. So any bill that says we can have a single set of considerations that must dominate the consideration of Parliament and parliamentarians is actually going to limit our democracy. And we think that any democratic organisation, such as Parliament, would be very keen to reject limitations on our public debate, limitations on how we evaluate legislation and regulation. And I hope that in the end, the strong sentiment of this democratic nation is heard and this bill is terminated.
Okay, thanks, Ms. Gray. You've left us with plenty of time for questions. I'm going to go to Dr. Russell.
Hey, Sandra, nice to see you. Lots of things to talk about. But two things first up. You say you've consulted your members on this, or you're talking about your members' opinions. Can you tell me the process you went through to gather that opinion or that feedback?
Look, our members are continually in conversation with us. And I'd say the biggest part of our movement is always we have a major conference as a union in which our members strongly express their desire to not only be in a democratic union, but in a democratic society. So they urge us at all times to protect democracy, but also in terms of Te Tiriti o Waitangi, we are a co-governed union. 50% of our council are Māori, 50% tangata Tiriti. We got there by doing 166 hours of meetings to make sure that TU members understood what it meant to be a true Tiriti partner. And that's why we're absolutely very strongly submitting that any piece of legislation or regulation in New Zealand that wipes out our obligations to Te Tiriti o Waitangi cannot be accepted. I mean, 166 hours of consultation is a pretty big consultation for a small organisation. It was very clear from our members. Te Tiriti o Waitangi is our founding document. It is an active partnership relationship for a union as well as a country. So, we absolutely make sure that democracy thrives, and we don't. We do have a set of values, very broad values by which we evaluate our own actions, but we don't limit it to one particular perspective. And I think that's where this bill really rankles our members as well, is There is one singular perspective, ideological perspective, dominating this piece of legislation, which does not allow those of us who believe in collectivism to have a say, a proper say in the running of their country. So hopefully that gives you an idea of how hard we work and why our members sadly want you all to work very, very hard every time there's a piece of legislation.
Yeah, I know how hard you work, actually. I have had that experience. Look, paragraph 4.2 of your submission, you mention the public tertiary education system. You say that the values in this individualistic bill would undermine that. Can you speak a little more to that as to how?
Well, absolutely. Tertiary education, of course, is a public good. Individuals do benefit from getting a tertiary education, but the system as a whole is there to absolutely support the whole country and the public good. And when you put in absolute requirements around private ownership, private property, privatisation, you are actually undermining that public good. And that's going to be the detriment of our economy, actually of individuals, and of any values of democracy. So this is not something, regulation in our sector should never prioritise the individual. It should always look first to the public good. This type of legislation or this type of constraint on legislation and regulation will constrain our sector from focusing on the public good.
Ka pai, thank you.
Okay, Mr. Ferris, takata.
Tēnā koe, Sandra, and thank you for your submission. I just want to pick up, and hey, thank you for the 160 odd hours you put into working through things in a constitutional and honouring fashion with regards to Te Tiriti o Waitangi. So I'm interested in the membership of your rōpū and how you come to the agreement space where you're working as tangata whenua and tangata tiriti. Now, we all know that ACT has a very low opinion or view of the relevance of Te Tiriti o Waitangi, and you and your group take a view that Te Tiriti o Waitangi is actually an active thing. I wonder if you can just explain to us, the sentiment within your rōpū about Te Tiriti o Waitangi being an active treaty in 2025.
Look, it does start, of course, with the historical acts that come in 1835 and 1840, but it is an ongoing relationship. So we have always worked very strongly with the work actually of the late Moana Jackson and the idea that this is all about a relationship, sitting down face to face in equal numbers and saying what is good for us all. And that does mean, interestingly, it changes the nature of the decisions you make. And recently, the commitment to advancing Te Tiriti o Waitangi, to advancing Te Tiriti values, to advancing Māori values became the top priority at our recent conference. In past, it wouldn't have made it there, but because we have this active relationship, because we have members sitting together, tangata tiriti, tangata whenua, sitting together talking about why it's important, it changes the nature of what you do. And this is Aotearoa. This is what Aotearoa has to be. And it is the only vision we have as a union. And we're appalled that anyone would try and resist us building a better nation face to face, together, working hard. We haven't got all the solutions and we're still working it through, I am going to say, but we're committed to staying at the table and we're committed to advancing Te Tiriti o Waitangi and won't watch as our sector gets equity measures ripped out, gets tiriti measures ripped out. We will continue to fight. Tangata whenua, your nation, your land, your rights, that's it. We have to fight.
Okay,
Sandra.
Thank you very much, Sandra. We're at time. You managed to get a lot in and some good interaction there, so thank you, and all the best with the rest of your day. That takes us to the PSA. Have we got them online, Danila?
They're here in person.
Oh, they're here in person. Oh, even better. Okay, the screen's just frozen. No, you're away. Okay, look forward to your presentation. Please introduce yourselves, and you've got 10 minutes, and hopefully we'll have some time for a bit of Q&A at the end.
Thank you. Tēnā koutou katoa. Tō ko Kerry Davies tōku ingoa, National Secretary, PSA Te Pukenga Te Here Tikanga Mahi, and with me is Andrew McCauley, who's a policy advisor with the PSA.
Kia ora.
So the PSA, as you may be aware, is the trade union for public and community service workers. The PSA represents 95,000 members, including 33,000 members who work in core public services. Our public service membership includes workers who would need to operate within the framework of this bill to develop, implement and deliver regulation. And our wider membership encompasses thousands of people who would be affected by this bill because it affects all New Zealanders across across communities. In addition to the PSA's main submission, which you should have in front of you, I presume, where several other parts of the PSA, our sectors and networks have also made their own submissions, and they include the community public services sector, which are the sector which covers NGOs, iwi organisations, for-profit and not-for-profit organisations that are publicly funded, the Eco Network and the Women's Network. I need to strongly tell you that we oppose this bill and we want to see it terminated. It is flawed and detrimental to the public interest, and for this reason should not proceed. The bill isn't, in our view, an effective way to improve the regulatory system. It duplicates systems, processes and roles that already exist to help ensure good practice and ensure that important matters have been given adequate consideration, such as the regulatory impact analysis process, the legislative design guidelines, and the Legislative Design and Advisory Committee. The bill is unhelpful and confusing by covering some of the same things as those components, but not all of the same things. You will be aware that agencies have said that the components of the proposed bill would duplicate or add complexity to the existing tools for regulatory quality and transparency. So we're not the only organisation to call this out. We know that there is always room for improvement in any organisation's practice, system or process, whether that's Parliament's or whether that's through the officials providing advice and drafting regulation. And if that's considered necessary, there would be other ways of doing that improvement, ways that don't involve further complicating the regulatory system. The bill is not about improving effectiveness and accountability or good practice. It's about embedding extreme libertarian views into lawmaking. The bill goes far beyond technical quality and instead seeks to dictate the content of laws based on particular beliefs about what kind of laws are considered good ones, based on the ideology of a political party. Of course, we know, excuse me, making decisions informed by ideology and a political viewpoint is a core part of what MPs are in Parliament to do, but it's a decision for politicians to make about what laws they pass, rather than one party locking in a set of ideological beliefs that then dictate what further legislation needs to be assessed against. And we believe that that is a very significant point to be taken into account. We think some of the principles of this bill are incompatible with the values most New Zealanders hold. It prioritises individualism and private property rights above all else. It is a giant leap backwards to less enlightened days when elites of some property owners, because we know that not all, for example, Māori property owners, dominated and excluded others from exercising political rights in our past. New Zealand and other democracies rectified that injustice. We cannot go backwards. The bill's principles prioritise private wealth and profit over the public good, by including clauses that elevate considerations around private property rights and assume that businesses should be compensated if they stand to lose profit because of regulation that would protect or enhance the public good. This bill adds rules to favour and protect privilege and would inhibit legislation designed to address inequities and correct historical injustices. Property rights have no place trumping human rights. The PSA supports the Council of Trade Union submission and draws your attention to the following statement by the CTU in their submission, which I'll quote. Unlike life, liberty and the security of the person, which is contained in Article 3 of the Universal Declaration of Human Rights, property ownership is not a natural right that is fundamental to our existence and moral agency. This is well recognised in moral philosophy, human rights law and the constitutional framework of most developed countries. Elevating property rights to have the same status as fundamental human rights would make New Zealand an international oddity and damage our reputation. The selective principles in this bill are not neutral standards of good regulatory practice. They seek to embed individual and private property rights over collective well-being, environmental standards and public interest. There are other principles far more widely accepted and relevant to our current times than the selective ones identified in this bill. Principles such as whether legislation is consistent with Te Tiriti o Waitangi, consistent with other existing legislation and international treaties, whether it is evidence-based, enforceable, adaptable, equitable, practical and sustainable. This bill is intended and would make it more difficult to regulate in the public interest. The minister responsible for this bill has been at pains to point out that the bill doesn't necessarily stop Parliament from doing anything. And if that was the case, the bill would be pointless, but not necessarily harmful. But in reality, the bill seems designed to set up expectations and procedural hoops that will make it harder to get across the line legislation or regulation that would work for New Zealanders and our environment. The bill would create expectations of what constitutes responsible government and would exert pressure on ministers to favour options consistent with the bill, even if they are not in the best interests of New Zealand. Those expectations would flow through to agencies providing policy advice, tilting the balance in terms of what kinds of options would be seen as palatable to ministers. The ability of the Regulatory Standards Board to make declarations would exert further pressure. Even in cases where ministers see it as appropriate to depart from the principles, the bill provides opportunities to tie up government agencies in red tape in developing statements of consistency, providing information for the Regulatory Review Board and responding to complaints under the complaints provision of the bill. Principle 8C of the bill, the principle that people should be compensated for any restriction on their use of property, would be a barrier to regulation that's intended to add to the public good by things like addressing inequality, protecting our environment, or reducing monopoly power. It creates an expectation that public funds that are desperately needed to fund vital public services like our health system, funds that this government has undermined through the tax cuts it has already given to the wealthy, would need to be handed over to businesses as the price we pay to stop them doing things that are harmful to our collective well-being. It would make regulating in the public good prohibitively expensive, making the barriers to action even greater. Ultimately, the bill would create a situation where the odds would be stacked against any form of regulation that promoted the public good over the profitability of business interests. The bill is about tipping the balance to be more in favour of profit over people and the planet. The bill is also a waste of public resources at a time when public services are already stretched and under-resourced. The Ministry of Regulations analysis suggested the bill could cost around $18 million per year through increased workload for public service agencies associated with additional analysis, alongside at least 1.1 million in additional support from the ministry and at least 1.04 million in resourcing the Regulatory Standards Board. Agencies have said that this bill is likely to result in opportunity costs through a reduction in the scope of other policy work being undertaken. After 18 months of cuts to essential public services, it's hypocritical to simply be okay with millions of dollars in wasted effort on a system that's not needed and not the most effective solution to a problem, which goes to satisfy the ideological leanings of the Minister for Regulation.
Okay, we're just going to have to wind up, and then if I can just get you to make your closing comments. We're on the 12th minute, and I'm just conscious that we need to move on. So thank you.
This will be covered by our runanga, but we also importantly in the general submission from the PSA want to point out that the bill undermines Tertiary, and it is disappointing to see that the Waitangi Tribunal's recommendation to halt the bill's progress has not been adhered to. And we want to conclude by reiterating that we oppose the bill and we urge the committee to recommend that it does not proceed. And thank you for your time.
Oh, thank you. We haven't got an opportunity for questions, but that was a very fulsome submission. So we thank you for coming into the Select Committee room and presenting this afternoon.
Thank you.
Thank you. Okay, Danella, who have we got queued up next? We've got
got
Ngā Rangahautira.
Yeah, we've got Te Kahuta from the next submitter.
Okay, very good.
Kia ora. Can everybody
ora.
see me okay? Kia ora. Kia ora ko tēnā koutou ko Te Kahuta toku ingoa. He rea ho no Ngāti Tuwhare tō me Waikato Tainui hoki. I'm here to represent Ngā Rangahautira, the Māori Law Students Association at Te Herenga Waka, Victoria University of Wellington, and its law reform subgroup Ngā Kai Aronui. For some background, we have a membership of approximately 300 Māori tauira studying towards the Bachelor of Laws. We seek to empower Māori law students to express their views on law reform and utilise the skills we learn at law school for the benefit of Te iwi Māori. I thank the committee for the opportunity to speak today, and I take our submission as read. While we are supportive of efforts to improve the quality and effectiveness of regulation in Aotearoa, we are strongly opposed to this bill for the reasons that have been set out in our written submission. Namely, that it represents a constitutional overreach, undermining parliamentary sovereignty and overstating the rule of law, that it is ideologically driven, embedding libertarian principles into law without democratic mandate, and that it is silent on Te Tiriti o Waitangi, failing to engage with Māori, tikanga, all the principles of partnership and protection. Finally, that it reflects poor legislative design developed without meaningful engagement or partnership with Māori. Turning first to the constitutional overreach, the bill introduces a binding pre-legislative certification that requires proposed laws to comply with a set of principles of good regulation, as we've heard many times today. These principles, which focus narrowly on limiting government intervention and protecting private rights, prioritise a particular ideological stance over the democratic role of Parliament. In establishing an independent regulatory standards board to monitor compliance, the bill creates an additional layer of oversight that is not accountable to Parliament or the public. It takes away the capacity of portfolio ministers to be responsible for the regulatory features of the bills that they design, introduce, and administer. And this added layer will make government decision-making much more difficult and impose many new costs. This framework risks stifling legislative innovation and undermining parliamentary sovereignty. As Sir Geoffrey Palmer so aptly put, constitutional standards must derive their legitimacy from broad democratic consensus and foundational legal authority. This bill does not possess either of these characteristics. The Minister's preliminary consultation showed that it was supported by only 0.33% of 23,000 submitters. The Legislation Design and Advisory Committee are critical of the bill in their submission, and further, the Minister's own Ministry for Regulation has strongly advised against the bill. We also submit that this bill fundamentally fails to uphold Māori rights under Te Tiriti o Waitangi. It contains no reference to Te Tiriti, a silence that, at this point in this government's term, we consider deliberate. This omission undermines existing statutory rights held by Māori and blocks the pathway for the future development of treaty-based obligations. By promoting a model of equal treatment, the bill effectively erases the legal recognition of equity and partnership that Te Tiriti requires. This bill also fails to meaningfully engage with tikanga Māori or Māori decision-making frameworks. Its narrow focus on individual property rights and economic efficiency is incompatible with the collective intergenerational nature of Māori relationships with whenua and the responsibilities of kaitiakitanga. This intergenerational focus is why Māori consultation and partnership is so important, because Māori aren't thinking on a 3-year parliamentary cycle, but rather are more mokopuna-minded, steeped in manaakitanga and tipuna-driven. Further, the bill does not even meet the most basic standards of consultation with iwi and hapu. As Professor Andrew Geddes has noted, this lack of engagement constitutes a breach of the principles of Te Tiriti, which require Māori participation in the development of laws that affect our rights and interests, as has been canvassed today. Secondly, I'd also like to turn to the rule of law. We submit that this bill prioritises individual property rights above all else, disregarding the needs of hapu, iwi, communities, and te Taiao. It sidelines the public good, weakens environmental protections, and fails to recognise the independence of people, law, and sustainable development. This is not a neutral rebalancing of legal principles. It represents the imposition of a singular ideological worldview, an aggressive, libertarian, and deregulatory agenda that would entrench corporate influence and undermine community sovereignty. Ngā Rangahautira submits that the bill's interpretation and application of the rule of law risks undermining long-standing efforts to achieve equitable outcomes for Māori. Although the bill does not explicitly prohibit treaty-compliant legislation, it establishes a legal framework in which such legislation could be viewed as inconsistent with its core principles. This could have a chilling effect on good policy, whereby ministers or agencies hesitate to advance initiatives that, while necessary to uphold equity and Te Tiriti commitments, risk being flagged as non-compliant under the bill's narrow standards. Without explicit safeguards, the bill's warped version of the rule of law could be used to challenge or delegitimize policies that address systematic disadvantage simply because they involve differential treatment to achieve equity. As we set out in our written submission, the risk is that this principle would elevate formal equality over substantive equality. Finally, I would also like to just take some time to discuss today our concerns around parliamentary supremacy and the legislative process that we are experiencing. As Māori rangatahi and students, NR has engaged in the select committee process for approximately 9 years now through our subgroup of Ngā Kaiaranui. We have been engaging in good faith on the belief that making submissions was a meaningful way to contribute to the democratic process. But I lose faith in this process when the government continues to disregard public input, expert advice, procedural norms, evidence, and constitutional principles, pushing through radical changes regardless of overwhelming and clear public opposition. We are watching our democratic safeguards erode in real time. And it is a continuous insult and so incredibly disappointing that this government continues to wield parliamentary sovereignty as a tool to avoid actual accountability and good lawmaking. For Māori to be told that law changes, which so fundamentally and detrimentally affect our rights, are justified because Parliament is sovereign or Parliament has the lawmaking power, is an even further insult. We see no commitment to constitutional integrity and due process. In a country governed by an uncodified constitution, we are deeply concerned by what appears to be a deliberate attempt by the proponents of the bill to consolidate and impose a narrow, extreme, and unpopular ideology on the nation. This is a blatant exploitation of our system that relies heavily on convention, integrity, and good faith. To conclude, the RSB, if enacted, would introduce an ideologically driven, constitutionally questionable framework that undermines the principles of parliamentary sovereignty, democratic legitimacy, and treaty partnership. Its failure to engage with Māori, to acknowledge Te Tiriti, or to reflect Aotearoa's constitutional duality renders it unfit for passage. So for the reasons outlined, we submit that the Regulatory Standards Bill must be withdrawn. Ngā mihi nui kia koutou katoa. I welcome any questions.
Oh, thank you. We're nearly at time, but I'll take the first one from Duncan Webb. Dr. Duncan.
Kia ora. Look, thank you for that submission, really useful. I thought I'd ask you this because you've got a kind of rangatahi voice, and that is this bill focuses on individual property rights. Doesn't really capture any duties owed to future generations. It's not forward-looking. Can you comment on that?
Yeah, I mean, I think as I sort of discussed in just this process in general, it's already just really disappointing. And then even the way the bill is framed, it clearly prioritizes corporate interests over those of us who I suppose have less ability to maybe make initiate court proceedings or have any real power to have a say.
Okay. Look, I'm just going to have to leave it there. Thank you so much for your presentation, loud and clear, and we appreciate you appearing before us this afternoon.
Mr. Chair?
Yes.
Just wondering about whether you've got a government quorum at the moment. We've only got Andy Foster on a name, not an actual person.
Okay, I'll look into that.
Thank you.
Thank you. Okay, that takes us to Pou Taiao. If we got them on board, Danella?
Yes, we do.
Okay. Ricky Ellison. Kia ora, Ricky. You've got 10 minutes. We look forward to your presentation, and leave us a little bit of time for some Q&A, if you can.
Thank you, Chair. Tēnā tātou. Ricky Ellison, Haurio o Ngāi Tahu Ngāti Tō Rangatira Te Aotearoa Hoki. I'm presenting on behalf of the Pou Taiao Leaders Group, which is part of the National Iwi Chairs Forum. As you may know, the National Iwi Chairs Forum comprises the chairs of over 70 iwi from across Aotearoa, and these iwi are some of the largest landowners in Aotearoa and also control some of our nation's largest commercial operations. The Pou Taiao Iwi Leaders Group fundamentally opposes the bill and seeks that it is abandoned. The bill is unjust, unconstitutional, undemocratic, unjustified, and unnecessary. It intentionally excludes references to Te Reo Waitangi and ignores its constitutional status in the legal framework of this country. This is despite recognition of Te Tiriti across the legislative, judicial, and political landscapes. In addition, Te Tiriti is also one of 3 fundamental objectives of high-quality legislation identified in the existing legislative design and advisory committee guidelines. The Waitangi Tribunal also found the bill as proposed in the process by which it has been developed is itself a breach of Te Tiriti. Ironically, the same lack of consultation with Māori that the Tribunal identified as a breach of Te Tiriti principles is also a breach of the proposed standards outlined in the bill itself. That is, the importance of consulting directly with the persons material and directly affected by the legislation. Indeed, the proposed principles of responsible regulation, including those relating to good lawmaking, are extremely narrow in scope and heavily skewed towards the narrow neoliberal philosophical views of the Minority Act Party. It seems logical that if the true intent of this bill is to encourage good regulation, that ensures that more effort would be put into seeking to develop a regime with broad bipartisan political support. Such an approach would be more likely to be more enduring and effective. Given opposition parties have all stated they will repeal this bill, it is unlikely to have enduring impact on its current format. Also, even when judged against the narrow neoliberal principles proposed in this bill, the bill itself fails on principles of cost benefit and other principles as stated in the bill, such as effectiveness and proportionality. Particularly given the complete lack of a clear problem definition this bill is purporting to address. Much of the other legislation acted by this coalition government, particularly under the regular use of urgency provisions in the House, would also fail to meet the standard proposed in this bill. This does leave us to wonder if this is a case of do as I say, not as I do, and if the bill will be selectively applied for political expediency. Given the lack of reference to Tertiary in the bill, Pou Taiao is also gravely concerned about the potential impacts on the Crown's ability to meet its ongoing treaty obligations to iwi, hapu and Māori. This includes existing treaty settlement obligations, especially concerning in light of the recent Office of the Auditor General report highlighting the Crown's already failing to meet existing treaty settlement obligations. And while we also acknowledge the Treaty Settlement Acts are proposed to be excluded from the ambit of the bill, this exclusion is very narrow and overlooks a number of realities. The rights and interests of iwi and hapu are not limited to treaty settlements. Treaty settlements only address Crown breaches of Tertiary prior to September 1992. They do not codify or create our rights and interests. Our rights and interests existed before the treaty settlements, and they continue to exist well beyond them. The Crown obligation is also to recognise and provide for those rights and interests. Secondly, treaty settlements are negotiated in the context of the wider legislative framework. They are interdependent on multiple other statutes, such as the Resource Management Act. And so while treaty settlements might be excluded from the reach of this bill, it will still have significant impacts on settlements through the impact on other statutes being potentially changed. Materially amending the provisions of other statutes, such as the RMA, will directly undermine existing and future treaty settlements. There's also a range of unresolved rights and interests that are yet to be resolved with the Crown, including our rights and interest in fresh water. The Crown itself has acknowledged those rights and interests exist in Right Honourable Bellingish's statement, affidavit to the Supreme Court and the mixed ownership model case back in 2012, I think it was. And that's been acknowledged by this government as well. A range of other mechanisms that already exist will also be indirectly recognising rights and interests of iwi and hapu, particularly in the Taiao space where Pou Taiao operates. These include joint management agreements, mana whakahono wairohi, and other arrangements under the RMA, and all these will be at risk under this bill. Councils and iwi have made significant progress in building strong and effective relationships in the management of the Taiao, which has all been put at risk by the potential impacts of this bill. Much has also been made of the focus of this bill on the private property rights. As I noted at the start of the submission, the iwi and hapu represented by the National Iwi Chairs Forum are some of the, well, for Naito's case, are the second to the Crown, the largest landowners in the South Island. And iwi and hapu are significant landowners in this country. As I said, we also control significant commercial interests and are well placed to comment on private property rights. The problem with the discourse around private property rights is that they solely focus on the rights of the property rights holder and not our obligations or our commitments to each other or the Taiao. They're placed in the rights of those private property owners to exploit those resources with very little recognition or discourse around the impact of those resource use on the Taiao or the wider community.
Improving legislative quality and regulatory design. This is
for example, we talk about privatising those profits from the use of resources, but we don't talk about sharing the cost. Well, the cost of those impacts are not shared. They are shared by the wider community, and that cost is not borne by the use of those rights. And I think that's part of the biggest problem we have with this discourse around private property rights. With capitalism for profit, and when we socialise the impact of that exploitation. And in my 30 years of working with iwi industry, councils, government, primarily in Taiao issues. I think everybody has always said they want better environmental outcomes. They want cleaner water, they want cleaner rivers, they want their kids to be able to do the things that we did when we were kids in our Taiao. We're not going to get that with this bill. This bill, in terms of the focus on private property rights and the exploitation of those resources, without a recognition of that obligation we have to each other and to Taiao, will totally undermine those outcomes everyone claims to be seeking. I'll probably leave it there, so open the questions. But anyway, just want to close with that Mātou whakatauki mō tātou mō ka uri a muri ake nei for us and for our children after us. So,
oh, kia ora, Ricky. I've got Tākura Ferris here for a question.
Tēnā koe, Ricky, ngā mihi nui kia koe me ngā mahi kawe nei e koe. Ricky, I'm really interested to hear from you and from your pocket of leadership in Te Iwi Māori what the bill is signalling to the people who lead Te Iwi Māori. And given in particular the recent, well, not discovery, but the recent publishing of the travel and the pace of the Māori economy and where the Māori people are heading, what does this bill signal to you as leadership within that travel and that journey of Te Iwi Māori?
I think on the one hand, we want to celebrate it, but we also don't want to acknowledge that the things that underpin that economy are that collective nature of our rights and interests, the collective obligations we have to our Taiao and the resources that we're utilising. And I think that's the fundamental, one of the fundamental problems we have with this bill, that it doesn't acknowledge that we have that obligation to the Taiao. We have the obligation to our future generations to provide a world where they can, kaitiakitanga is about providing for today and for tomorrow, right? This bill just doesn't do that. It focuses on a very short-term, future-focused, let's exploit it now and not focus on the future impacts that may have on our Taiao. I think that's part of our big problem. And that's, to me, I think it's not just Māori business, but I think that's what sets, that's a core focus of the Māori economy, is that obligation to the wider community and our wider whānau, iwi hapu whānau, and New Zealanders in general. I think we're doing this on behalf of everybody. It's not just about Māori. This is about a sustainable future for everybody.
Thank you, Mr. Ellison. Thank you, Mr. Ellison. We're just going to have to leave it at that because we're over time, but we appreciate your fronting up to the Select Committee this afternoon and enjoy the rest of your day. Okay, have we got Martin Andrews lined up?
He's here in person.
Okay, let's go straight to Martin. Thank you.
Tēnā koutou. Ko waiho, Aotearoa waka taranaki te maunga, pātea te awa, Ngāti Ruanui te iwi, Ngāti Tupito te hapu, Pariroa te pā. On my mother's side, my tupuna came from England on May the 2nd in 1852, settled in Woolston, just south of Ōtautahi, Christchurch, ko Martin Andrews tōku ingoa. I come here today as a proud but concerned New Zealander representing only myself. Thank you for allowing me to speak to you all today. Before I start, I just want to clarify that yes, I have read the bill. I have also read the regulatory impact statement that, as I'm sure you all know, gave this bill a quality assurance mark of partially meets. My question is, if it only partially meets, what part of the bill doesn't meet quality assurance? This seems like a fairly significant oversight for a piece of legislation that is designed to monitor every other piece of legislation. Shouldn't it at least pass its own quality assurance? To quickly summarise some of why I believe this bill is not in the best interests of our country. 1, the lack of consultation with Māori is not only a breach of te tiriti, but perhaps more importantly, it will profoundly damage the relationship between Māori and the Crown. Is it really worth alienating your treaty partner for your coalition agreement? While I'm here, I just want to pause to address this because this has been a consistent refrain from Minister Seymour, that no one has adequately explained to him how this bill breaches te tiriti. First of all, it would be nice if Minister Seymour could publicly explain how this bill does honour Te Tiriti. Secondly, as the author of this bill, do your own due diligence, as no one has adequately explained to him how this bill breaches Te Tiriti. First of all, it would be nice if Minister Seymour could publicly explain how this bill does honour Te Tiriti. Secondly, as the author of this bill, do your own due diligence. It is not the public's responsibility to educate you. If you had done appropriate consultation, we might have avoided all of this, and you might have a bill that reduces regulation while also upholding Te Tiriti. This is a democracy. It is the lawmaker's job to convince the public, not the other way around. 2, according to Minister Seymour, the ministry board will be made up of economists. This lack of balance should be disqualifying in itself. As I'm sure you're aware, we have never had a Māori minister for treaty negotiations, presumably for fear of bias, but apparently 6 economists can make balanced decisions when assessing legislation. I don't want to spend too much time focusing on the problems with this legislation because by now I'm sure I would only be repeating what's already been said. What I really came here for today was not to try to convince you of anything, but because I wanted to ask all of you a question to consider when it comes time to make your recommendation about the future of this bill. What is your vision for the future of our country? When that Union Jack finally comes off our flag and we have to define for ourselves who we are, what is your hope for post-colonial Aotearoa New Zealand, and does this bill move us all towards or away from that future? I can tell you what I hope for. My hope is for a country that elevates the best of our Indigenous language and culture and combines it with the best of all of the cultures that followed after it, where Te Reo Māori is interchangeable with Te Reo English and is ubiquitous across all levels of our society, where tikanga Māori sits side by side with tikanga Pākehā, and both cultures are uplifted by the other, where tourists come to our South Pacific paradise and enjoy her wonders because we have made careful decisions to care for and preserve her. I hope we can be an example as a modern country, not defined by colonialism, but one that chose to face its past, reckon with it, and then build something new. By failing to engage Māori, by prioritising individual liberty over collective well-being, by opening the door to corporate exploitation of our environment, I believe this bill moves us away from that vision of an equitable future and will further alienate the already vulnerable in our communities. If I were in your seat, there is no way I could support this bill, but I'm not. So the question is, what is your vision for the future of our country? If we don't start to define our country's future for ourselves, if we don't create an equitable vision and start building it, we will have these decisions made for us by people who do not have our country's best interests at heart. So again, I ask you, what is your vision for the future of our country? Ngā mihi nui, tēnā tātou katoa.
Okay, we are over time, but given that you've come in and made a huge effort, and I didn't want to stop you, I'm going to give Deborah Russell a quick question, and if you promise me a relatively succinct answer.
Kia ora, and thank you. That's a fantastic vision for our country. There's a really interesting line in your written submission where you talk about every person being equal before the law, and you ask the question, which law? Do you want to just elaborate a little bit on that?
Westminster law. I think that, which law are we talking about? Is it tikanga, Māori tikanga law? When that phrase that is repeated again and again and again, everybody is equal under the law, I think that sooner or later we're going to have to address which law are we talking about. Sorry, I forget off the top of my head the piece of legislation that was passed perhaps 1848 that brought Westminster law into Aotearoa and backdated it back to 1840s. And from that date, we have as a country existed under Westminster law. Westminster law wasn't designed for Indigenous people. It wasn't designed for a colonised people. It was designed in the Westminster system for the people of Westminster. So when we talk about everybody being equal under the law, what we're actually saying is everybody equal under Westminster law that doesn't take into any account how we need to behave as people of Aotearoa.
Okay.
Thank you.
Yeah, thank you. We're just going to have to leave it at that, Mr. Andrews. Thank you for coming into Parliament this afternoon, and all the best for the rest of the day. Right. Clark, does that leave us with the Honourable Marian Hobbs? Is she in the queue?
She's here in person.
Oh, she's here in person. She's just out of shot.
Just coming in.
She's very recognisable. Where is she?
There she is. Oops, is that meant to be on? All right. Oh.
Okay, my camera's just a little lagged. Good afternoon, Marian. We look forward to your 5 minutes. Thank you for your patience.
Thank you. Kia ora, he hoa ma. I hope you're still my friends by the end of this. My focus today is not as wide as some of the others, but it really comes from having been one of you, having been a legislator, and at all levels of legislation and on both sides. Well, there are only about two sides in. And it will be a practical presentation on the three main issues I was talking about. First of all, purposes. Read the bill, God save us. It really takes me back reading legislation. But I read the bill, and the purposes as laid out in the bill are generally okay. By the way, where do I look? Up there or here?
Yes,
there.
Straight through. It's like reading the news. Thank you.
Well, I don't read the news very often, but never mind. As laid out in the bill, all okay, but why replicate what we're already doing under our current structures, especially with additional cost? 5 or 6 economists don't come for nothing, and let alone the people who support them, and no proof that this will be an improvement to improving our legislation. But what worried me was that I came across a quotation from David Seymour the other day, in which he said that, yes, the bill, if enacted, will put up the costs of administration, will cause political embarrassment, and it will probably lead to people challenging through the Regulatory Standards Board and getting declarations that bad laws have been made. And that made me stop. And I actually think that the reality of the purposes is that this is a lobbyist dream, this legislation. It's got very little to do with improving legislation, but giving voice to those who may have missed out. And it's part of a political game. And when you play games with politics, you really weaken democracy. So the purposes as laid out look okay, but dig a little deeper and it begins to feel corrupt, actually. The principles. I've listened today to quite a few people doing really good explanations of the principles. I just want to give some examples. Yes, there is a real tension on individual rights versus the community. But even with individual rights, it's been property rights rather than necessarily human rights. And if I give you an example, there are codes, building codes written to enable disabled people to have access to a building. The property owner is faced with an extra cost, but the disabled person has a human right to have access to the building, i.e. Parliament, i.e. courts, etc., schools, places of learning, hospitals. They have a right to be in there. Then there's individual rights versus community rights. And here you see, I felt really sad at what was missed out. And of course I would be sad because I was a former Minister for the Environment. What we share together, our community, we share the air, we share the water, the oceans, our environment. If you take an example, Christchurch has a particularly awful thing, as shares with Alexandra and Arrowtown, of inversion. So that clouds sit on top and all the particulates never get through and go forward to be breathed in by the people below. So you have to control the particulates. And we did that through a National Environment Standard on air quality, which was then the standard gets set and then the regulations get done by those very good beings, regional councils. If you didn't do something like that, or at the stage before we passed that act, it was quite clear from the data that up to 400 people a year died in Christchurch in direct result to poor air quality. That's why you need regulations, got nothing to do with property, got an awful lot to do with community and public health. And another simple one is biosecurity. We had a terrible scourge of varroa mite. It couldn't have come in here accidentally. It could have come in by someone deciding to bring in a queen bee in a matchbox, breaking the regulations around biosecurity, and with, not unknowingly, because it's uninspected, with a varroa mite on it. Think of the costs that went down. Think of the costs that go down whenever somebody brings fruit in illegally with fruit fly and all the work that gets done there. So there are examples of community. And then there's the role of the Regulatory Standards Board. It duplicates poorly the work that's already been done. Any law that you take through goes through, if I take one about water, cleaning up the water in Lake Taupo, it's not all thought up by ministers. People come and lobby. I don't think all lobbying is bad. They come in and they lobby and they say there is a problem. Minister decides, okay, we fund the work around what is the solution. And that involves a whole lot of work out in the community and backwards and forwards and negative and positive and all those sorts of things. And then it goes up, and at the same time, by the way, Cabinet knows, the DPMC, the all loyal DPMC to which you must tug your forelock, and Cabinet committees and Cabinet itself, and then the House, and then select committees like this. And at select committees, there is the opportunity for the person who thinks they haven't been consulted enough to come in and have their say. And then there's the backstop of regulations review. So the time involved in that, the cost in that, the range of expertise and experience. I mean, I love, this is a really strange thing for an ex-minister to say, but I love the civil servants. I love the fact that they argued in front of me. They went backwards and forwards, that they teased out issues. Can 5 people on a board replicate that work? I do not think that they can.
Ms. Hobbs, I'll just get you to conclude your comments because I'd like the opportunity for at least one question.
That's beautiful. Thank you, dear. Just in the thing, just sort of saying, compare the depth of our public service with 5 people appointed to a board. And I've been appointed to boards and I know the difference. Thank you very much. And can I give a special thanks to the staff? You've had one hell of a job during this. I really appreciate what you've done. Thank you.
Yes, no, full credit to the staff on a good organisation. Here, we're going to go to one question, Dr. Duncan Webb.
Kia ora, Marian, thanks for that submission. Look, I'm going to invite you to speculate a little bit. This, in terms of the kind of touchstones for good lawmaking, if you had to pick 2 or 3, what might they be? And do they appear here?
One, I think, is absolute and thorough consultation and involvement of the community. I think that that's really important because a law is a communal thing. We are meant to, in here, in this place, we're meant to represent the law, all sides of it, all sides of the argument. So that must be available to be, and I can't see this in here. The very fact that it ignores Te Tiriti is just one example, a major example, of why this is not an inclusive piece of legislation. The second thing that I think about it is that I didn't get great evidence, except that I think that it's in that, my old age, regulatory impact statement. When you have the people who live this all the time saying they can't give top marks to this piece of legislation, I think that rings alarm bells. And truly, lovely people, Mr. Chairperson, I'd hang my head in shame if, in order to, be nice to a member of your coalition, you actually put your names and your votes to this piece of poor legislation. Thank you.
Okay, well, I think we'll leave it at that. Marian Hobbs, the Honourable, lovely to see you back in the precinct as always.
All right.
And enjoy the rest of the day.
I will do.
Yeah, no, thank you for your submission. Okay, have we got the Aotearoa New Zealand Employed Veterinarians Union Manatopu Incorporated?
Yes, they're here in person.
Oh, great. Thank you. Okay, you've got 10 minutes. We won't hold you up. We look forward to it.
Kia ora koutou katoa. My name's Dr. Yulia Pastor, and I'm representing the voices of Aotearoa New Zealand Employed Veterinarians Union, Manatopu, henceforth the Aotearoa Veterinarians Union. The Aotearoa Veterinarians Union is a voice for employed veterinarians across the motu. We advocate for fair and sustainable employment, science-led regulation, and the protection of animal welfare and public health. As an organization, we are committed to upholding Te Tiriti o Waitangi as a foundational and living document. Our Constitution recognizes that supporting Te Tiriti is a matter of tikanga, and we affirm the mana motu haka of tangata whenua. We approach all matters of veterinary-related public health, including this submission, through the lens of partnership, equity, and the respect for Māori rangatiratanga. We submit this statement to express our deep concerns with the Regulatory Standards Bill, particularly its potential to undermine science-informed regulation, weaken animal welfare and public health protections, risk frameworks supporting fair trade, and marginalize both veterinary and Māori voices in the shaping of law. I have 4 concerns that the union has raised, 2 foundational concerns with the bill itself, and 4 recommendations. Our 4 initial points of concern. Concern 1, undermining professional and scientific consultation. Veterinary professionals are charged with protecting the health and well-being of animals, humans, and the environment. This work is grounded in science, ethics, and law. We are concerned that the bill, by prioritizing abstract regulatory principles over practical expertise, risks eroding the long-standing expectation that regulations impacting veterinary practice will be developed in consultation with the profession. This includes, and is not limited to, public health measures to control zoonosis, veterinary medicine prescription frameworks, animal welfare standards, fair domestic and international trade, national and community-driven work safety protections for innately high-risk and dangerous working environments. Excluding or devaluating expert consultation in the name of efficiency risks serious real-world consequences for animals and human lives. Concern number 2, disproportionate empowerment of commercial interests. The bill creates a regulatory environment in which large commercial actors such as pharmaceutical companies, commercial pet breeders, and veterinary clinic corporates may be empowered to challenge regulation that restricts profit, even if that regulation serves a crucial public health, animal welfare, or fair trade purpose. We are particularly concerned that prescribing rights and medicine access could be contested. Ethical standards of breeding and animal care may be undermined. Commercial interests may begin to shape veterinary and agriculture regulation to suit profit motives. This would place veterinarians in ethically compromised positions and undermine both public trust and professional integrity. Concern number 3, marginalizing Te Tiriti and Tikanga Māori. The bill contains no recognition of Te Tiriti o Waitangi, nor any mechanism to ensure tangata whenua have a role in the development or review of regulations. This is a direct conflict with the principles of partnership and equity that must underpin all lawmaking in Aotearoa, especially in healthcare, including veterinary medicine. If enacted, the bill could disempower Māori in regulatory processes that affect whenua, wai, and tonga species, undermine existing protections informed by tikanga and motaranga Māori, contradict the commitments that many agencies, including the veterinary profession, have made to genuine tiriti partnership. Any legislative framework that fails to uphold Te Tiriti is by definition unjust. Concern number 4, chilling effect and legal uncertainty. The bill's abstract regulatory principles may invite litigation, dissuade necessary regulatory reform, and create confusion amongst agencies tasked with protecting health and safety. Veterinary, biosecurity, and welfare laws must be responsive, not frozen by fear of failing a regulatory checklist. Now, our 2 foundational concerns with this bill. Again, while we offer recommendations, we must first express serious concern about these 2 structural aspects of the bill that fundamentally compromise the integrity of Aotearoa's regulatory system, especially the veterinary public health regulatory system. Foundational concern number 1, misaligned regulatory principles referencing subpart 1, section 8 of the bill. The proposed principle of responsible regulation are rooted in narrow interpretations of legal liberalism, emphasizing economic liberties, individual property rights, and abstract procedural norms. These principles do not reflect Aotearoa's constitutional realities, particularly Te Tiriti o Waitangi, nor do they account for public good, environment protection, or Motoranga Māori. Without grounding in Te Tiriti obligations or One Health values, these principles risk undermining regulation that serves collective well-being, scientific integrity, or tangata whenua rights. As a foundational component of the bill, this section must be entirely rewritten or reflect the legal and ethical commitments of our nation. Foundational concern number 2, dangerous centralization of power, referencing subpart 2 of the bill. The bill grants extraordinary power to a single minister, chosen by the government of the day, to appoint members of the Regulatory Standards Board without meaningful checks, public consultation, or requirements for professional or scientific expertise. This board would be empowered to assess, influence, and potentially veto primary and secondary legislation across all sectors based solely on the misaligned principles described in our first foundational concern. This representation of radical departure from our current framework, in which regulatory boards such as the National Animal Welfare Advisory Committee operate with expert membership, statutory constraints, and limited scope. No existing veterinarian regulatory linked body possesses the sweeping authority envisaged here. To consolidate this much interpretive and gatekeeping power in a politically appointed body is not only undemocratic, it risks undermining trust, transparency, and sectoral engagement across the board. Unless both of these, the flawed regulatory principles and the unchecked concentration of authority, are resolved at the structural level, the recommendations we outline, the 4 recommendations we outline cannot achieve their purpose. Reform must begin with these foundations. Our 4 recommendations. Recommendation 1, explicit inclusion of Te Tiriti o Waitangi obligations. Amend the bill to include a statutory requirement to uphold the principles of Te Tiriti o Waitangi and ensure the meaningful partnership with Māori in the development and review of regulations. Recommendation 2, safeguards for scientific and professional expertise. Protect the role of registered professionals, especially in health, science, and welfare fields in both the creation and review of regulations that affect their practice. Recommendation 3, exempt critical health and welfare legislation. Carve out core regulatory frameworks such as the Animal Welfare Act, Agriculture Compounds Veterinary Medicines Act, Biosecurity Act, and Health Act, to name a few, from the bill's scope, or provide for a higher threshold before such laws are subject to challenge. Recommendation 4, substantially rewrite or withdraw the bill. Given the scale of concern raised by professionals, Māori organizations, unions, and environmental advocates, we recommend that the bill is substantially rewritten or withdrawn entirely. In conclusion, as veterinarians, we are stewards of well-being, not only for animals, but also for people and our shared environment. Our profession stands on the pillars of science, ethics, and public service. These must not be undermined in the name of regulatory convenience. As a union, the Aotearoa Veterinarians Union also affirms that Te Tiriti o Waitangi is not optional. A just regulatory system must honor the covenant and uphold the mana of tangata whenua. We call on the committee to reject the bill in its current form and to commit instead to a process of regulatory reform that is inclusive, evidence-based, and tiri honoring. Ngā mihi nui, Drs. Yulia Pastor, Simon Clark, and Maddie Jordan, officers of Aotearoa New Zealand Employed Veterinarians Union, Manatopu. Thank you.
Thank you very much. Look, we'll have to leave it at that. We've had 12 minutes, but thank you so much for coming into Parliament and giving us that full and fulsome submission. Thank you. Okay. Have we got our next individual presenter, Mr. David Small, lined up, Clerk's office?
Yeah, he's just online.
Okay. Mr. Small.
Thank you. Kia ora koutou, ko David Small toku ingoa. I'm a lawyer and an academic working at the University of Canterbury in Ōtautahi, Christchurch. I find this bill incredibly disturbing, both in its content and in its demonstration that this government is so weak that it's allowing David Seymour enact far more influence and power than the country ever intended. I'm heartened that despite Seymour's saturation coverage in the media, he's still ranked only 5th in preferred Prime Minister stakes. New Zealanders see him and we don't like him, yet here we are with legislation designed to make his narrow libertarian neoliberal perspective the yardstick by which we determine how this Parliament makes laws. We're facing the serious prospect of enacting David Seymour's wet dream, the framework that has been proposed and turned down previously 3 times in Parliament, a bill that goes against the advice of his own ministry. Seymour's contempt for democracy is well documented and despicable. He makes baseless Trumpian dismissals of those who oppose him as bots. And with this bill, he's individually targeted his critics as deranged. He makes out this bill is just about improving the quality of lawmaking, but it's a pernicious attempt to force through his narrow ideological agenda, dressed up as a commitment to equality. Seymour's like a wannabe Elon Musk, let loose across all sectors of government to advance an agenda that pushes his ideology and favours the wealthy vested interests that back him. Interests that gave him over $4 million in the last election, not much less than the far bigger Labour Party. And we all know that it's those interests like Atlas and New Zealand Initiative whose affiliates and ideology would dominate in the powerful non-elected regulatory standards board that this bill seeks to bring into effect. A significant justification for this bill is the absurd idea that New Zealand is grossly over-regulated. This is often expressed in sound bites about removing red tape. The gall of trying to sell this to New Zealanders who've seen and experienced the consequences of deregulation. Tell the Pike River families that less deregulation is best. Tell it to the people impacted by leaky homes. The trouble is that National and New Zealand First are going along with this. Unlike with the Treaty Principles Bill where they humoured ACT but ultimately did the right thing, the real danger here is that they do not see beyond the soundbite of cutting red tape and allow this bill to pass. As Max Harris pointed out, the bill is not only not required by the coalition agreement, it's actually counter to essential elements of that agreement. National and New Zealand First can and must stop it. The bill should be rejected both for what is in it and what is not in it. With the Treaty Principles Bill, Seymour hoped that he would tap into and ride a wave of anti-Māori sentiment, but he misread the room. We proved that the country has changed since Don Brash's anti-Māori Orewa speech over 20 years ago. The groundswell of opposition to that bill made it crystal clear that despite our different perspectives, New Zealanders believe that we should take seriously the guarantees in Te Tiriti o Waitangi. Yet here we are with this bill, claiming to be the essential bedrock of who we are as a country, that excludes any mention of Te Tiriti. As a 4th generation Pākehā, I find this omission deeply offensive. It dishonours the efforts of countless New Zealanders, Māori and non-Māori alike, who have worked to address historical injustices in this country. The bill promotes the principle that every person is equal before the law, but in the context of the anti-Māori and anti-poor thrust of this government, we know what that really means. It's code for obstructing any legislation that seeks to address the profound inequalities and injustices that have been a feature of New Zealand society since its inception. In a society as unequal as ours, to impose a strict adherence to equality has the effect of entrenching greater inequality and injustice. There's no basis to the ideological position that this bill denies the existence of structural injustice and inequality. The bill reduces rights to the right to own, use and dispose of property. The important provisions of the already weak New Zealand Bill of Rights Act, which came into force 35 years ago, are overridden by a narrow 17th century John Locke view of property rights. Also absent from this bill is any recognition of the importance of environmental survival. We are witnessing increasing evidence around the world and in Aotearoa of the devastating impact of climate change, extreme weather events, rising sea levels and CO2 emissions that threaten the very survival on this planet. Yet this is deemed less important for legislative principles than individual and corporate property rights. This is a shocking bill and a call on the committee to reject it in its entirety. Kia ora.
Oh, thank you. That was perfectly timed, Mr. Small. We haven't got time for questions unless anyone's got anything pressing. I'll go to Rawiri Waititi on the promise that it's a short question and a succinct answer. Rawiri.
Kia ora. Thank you, Mr. Chair, for the opportunity. Thank you, David, for that comprehensive presentation. I've just got a very quick question. Why do you think this bill protects private property rights, but not consumer rights, tiriti rights, or human rights?
I think that's an illustration of the narrow ideology of it. It's entirely focused on property rights and elevates them above it. And it's a narrow perspective that ACT has always promoted and that New Zealanders have consistently rejected.
Kia ora. Thank you, David.
Okay, thank you, Mr. Small. Thank you for your time and your submission. We're going to go to Annie Collins now for an individual submission, Clark.
She's here in person.
Very good. Okay, Mrs. Collins.
Kia ora.
Okay, kia ora. Sorry, the video's lagging a bit on my laptop. Please proceed. Welcome to Parliament, and you've got 5 minutes. And if you'd like some opportunity for Q&A, if you can come inside that'll be even better. Thank you.
I have some graphics with me, and I note that your camera is wide angle, and you're going to have trouble seeing them. I suggest that somebody adjust the camera for the following days. Kia ora tātou katoa. I'm Annie Collins. I'm an independent film editor, and I cut my first film in 1975. In 1982, I was asked to edit the Springbok Tour film, Patu, by Merita Mita, the most intelligent, fierce, and compassionate director I have ever worked with. Who Merita had to work with was a monocultural, monolingual, arrogant, and ignorant person, a product of the institutional racism built into our education system. Halfway through the year that it took, I finally realized that the person I worked beside had a life that I had no idea existed in New Zealand, and we were both born here. That realization was devastating. It undercut every value my parents taught me. It took away the ground under my feet. I had no place to stand unless I upheld my side of Te Tiriti o Waitangi. And that's why I'm here. I'm sixth generation tangata Tiriti, and it is my responsibility to uphold the best of my culture's values. My father lived by the rule that a man's word is his bond, because if it isn't, what is there to trust? So take a look at this, if you can see it. It's a diagram of 32 ministries and departments. This little fella here in the red is the ministry, the new Ministry of Regulation, which is meant to sit underneath and support all of those 32 ministries. We have a man's word that this will be the way that this new law will work. But I took a look at it, and if it is to work the way that he says it will, it's actually going to look like this. And that little box has become a great big one at the top, over and above 31 ministries and departments. And what cements that structure in place is another box on top of it for the RSB board. Those people will be personally chosen by the man who says we should trust him. At that stage, I was beginning to smell a really big rat. There's going to be one person who is in a very prime position. And there you have the structure with a very large man on the top. What it's actually called is empire building. So we do have to ask ourselves, do we trust this man's word? Well, we do have safeguards built into our Westminster system. We have the Auditor General, we have the Ombudsman, we have a Commissioner for the Environment. And also, we actually have a real Prime Minister. But all of them sit down here, in a little box down here. Because the problem I see is that the reports they write become irrelevant. The ministries are all busy trying to get the regulations they need through the gatekeepers and the courts, and avoiding the threat of international corporations suing us. Which brings me back to institutional racism. This is a system of gates designed to open for a specific section of the population. It's the most specific and excluding of over 80 laws that have established and embedded institutional racism in Aotearoa, New Zealand. And it's simply unacceptable, because I cannot access the wisdom of my Tiriti partners with this in place.
Okay.
I cannot keep my word with this in place. I cannot stand with honesty and in good faith in this land with this in place.
Ms. Collins,
And
I'll get you to
you.
just to give us your concluding remarks, just because we're over time now. Sorry to interrupt, but.
My concluding remark is that I cannot do any of those things, and neither can you. I thank you very much for the opportunity to speak. It has become a rare thing in this day and age. Thank you.
No, well, thank you for coming into Parliament, Ms. Collins, and thank you for your presentation. Members were all ears, I can assure you, looking on screen. So thank you for thank you for that. And
I will send copies of the graphics through.
Yes, no, if you can make sure the clerks have got a copy of that, and if the clerks, if you can make sure that that's put on a future email to us or distributed at a future meeting, that would be good, given that we're not there in person. Now we've got, thank you, we've got the Bay of Islands Maritime Park Incorporated queued up.
Yes, they're online.
Okay.
My name's Vicky Fruit. I'm representing Bay of Islands Maritime Park here today.
Welcome.
We're an incorporated society based in Bay of Islands. Our submission is that we oppose the bill, which prioritises individual and corporate property ownership or rights over protecting and enhancing the environmental qualities and value. And our particular concern is the expectation of compensation beyond that already provided for in Section 85 of the Resource Management Act. And if new rules, when new rules restrict the use of property, even if those rules are to protect and restore environmental qualities and values. So I'm just going to pick a couple of areas. The first is that of hindering or further hindering the passage of new protected areas legislation, which is actually overdue by at least 20 years. And we have joined the parties in committing to protecting 30% of New Zealand's coastal and marine areas by 2030. And at this stage, we've got 0.4% of New Zealand's protected marine territory fully protected in no-take marine reserves. And to achieve even a fraction of this protection, we require new legislation that is fit for purpose and not hindered by the requirement that the government compensate or potentially affected parties. The Resource Management Act approach, which we used here in the Bay of Islands and at Ngā Rangahautira to protect several small areas, has been effectively undermined by the recent proposed amendments to Section 32 of the Resource Management Act. In our case, with hapu, local hapu and forest and bird, we used the regional plan preparation process to establish two no-take areas in the Northland region. This process took many years, involved extensive consultation, negotiation, court hearings, and significant amount of expert evidence. So with that gone, our alternative is the Marine Reserves Act, which is unworkable in much of Northland because hapu consider it a statutory procedure. We need new legislation, but not one hampered by the requirement that government has to compensate fishers for any marine protected areas. Also, the second main point is that the Regulatory Standards Bill does not recognise publicly held rights, such as protected wildlife, fish and other aquatic life, and naturally flowing fresh water. In addition, the ocean and seabed are incapable of ownership. Nothing in the Regulatory Standards Bill recognises the importance of the environment and our duty to safeguard it for the future. So just going to note a couple of clauses, although there are more in our submission. Clause 8A2 and 8B should be removed. If by any chance 8B is retained, then the phrase "or the Crown" should be added to the end to recognise the Crown's many property rights. The reason for seeking removal of those clauses is in today's multi-crisis world, the importance of legislating for the common good must be preserved without the constraints that this legislation proposes. In some cases, the need for legislation may arise because landowners have made inappropriate decisions. And in such instances, legislation may be needed to require people to move or retreat from areas of severe coastal erosion or inundation, resulting from increased severity in storms and rising sea levels resulting from climate change. It may not be possible to compensate, especially at the level owners expect, and especially when risks were known. Clause 8C should be deleted because there are compensation provisions in the Public Works Act and Section 85 of the Resource Management Act. And of course, compensation is not payable or appropriate in all circumstances. And Clause 8C3 is particularly problematic. The beneficiary persons, wildlife, aquatic life, and freshwater may be unidentifiable or unable to pay. Future generations have an interest in the environment, but they are unable to pay now. And my last point is that section or subpart 7 addresses the Regulatory Standards Bill. We of course see no need for this entity, as legislation should go through the Parliamentary Select Committee as usual. And that ends my verbal comments.
Okay, thank you very much, Vicky. Any questions for Vicky? You've obviously satisfied everyone with your information. No clarity sought. So thank you from the winterless north.
That's okay.
Keep dry up there, and we look forward to seeing you one day in Wellington.
Okay, thank you.
Okay, hey, thanks so much for your submission.
Okay, thank you.
Right, thank you, Vicky. Members, it looks like we're going to have a small break with us due to start again at 3:10. So I invite you to turn your cameras and microphones off, and we'll recommence at 3:10. Okay, members, we'll give it 30 seconds. Danella, who have we got up next? Have we got People Against Prisons Aotearoa?
Yes, they're going to be online. It's going to be Tom Pearce.
Tom Pearce?
Yeah.
Okay, well, we'll just give it 30 seconds to make sure, because I did say 10 past.
Yeah.
Kia ora, can you hear me?
Kia ora, Tom. Yep, with 10 past 3, as I promised, we would be back on, and so nice to see you again. We look forward to your presentation. You've got 10 minutes.
Kia ora, thank you. Yeah, I know you're running to time, so I'll try and make sure that I keep to time as well. Kia ora koutou, my name's Tom. I'm submitting on behalf of People Against Prisons Aotearoa. We, PAPA is a prison abolitionist organisation. We work for a fairer, safer and more just Aotearoa. We're very strongly opposed to this bill, and we think that we're really strongly urging the committee to just reject it entirely. Just sitting here listening in, I've heard already so many reasons to oppose it. I just want to acknowledge all of those, the rushed and inadequate consultation, the fact that there's no actual mandate to pass this bill, ACT campaigned on it only passing by referendum, but it's now being pushed through as a government bill. The huge irony that this bill wouldn't meet its own standards, the obstacles that this bill creates for all sorts of good and necessary and important legislation, the way that this bill displaces Te Tiriti o Waitangi. These are all really good reasons and more to oppose this bill. And I'm confident that many of the other submissions you'll be hearing will cover these points. So what I want to focus on in my submission on behalf of People Against Prisons Aotearoa is the effect that this bill would have on the criminal legal system, for which prisons are sort of the end point. Our legal system, sort of taking the sum of all of our legislation, but particularly our criminal legal system, is already very heavily structured and sort of structurally biased towards the set of ideals that are contained within this bill. The principles within this bill reflect the ideals that are already within our, and already structuring our legal system. So particularly things like low taxation, the way that this bill elevates private property above other sort of equally important concerns, the way that it constrains regulatory intervention. These are all things that are happening already within our legal system. So we don't need this bill to come in and, tip the scales a bit further in that direction. And that's the effect that this bill would have. It's not legally enforceable, but the purpose of the bill is to sort of shape our lawmaking process in this direction. And the result of our current legal system, and what would be intensified by this bill, is that wealthy people, wealthy groups would, and already do, exert sort of disproportionate pressure on our laws. They have a disproportionate ability to shape and resist legislation and laws, via things like lobbying, media pressure, political donations, that sort of thing. And this bill creates even more avenues for those people to exert pressure on the government, to shape and to resist legislation even further, to tip the scales even further in their favour. The result of the current system, this has been happening for years and years. Our legal system is built up on top of this. And so we effectively have a dual legal system. What this looks like in the criminal justice system is treating the kinds of harm that gets committed by poor people far more seriously than the kind of harm that's committed by wealthy people. And I use the word harm here instead of crime, because a lot of the harm that's caused by wealthy people is not even in the Crimes Act. It's not actually a crime. In many cases, it's legal. So that's the way the current justice system works. And I wanted to just provide some examples of that to sort of illustrate this point, to show that we don't need this legislation to be even more in favor of the wealthy and powerful, because it's creating really unjust outcomes. So a good example, I think, is to compare something like benefit fraud with tax fraud. These are two very equivalent, kinds of crime, I guess. The average prosecution for tax fraud is somewhere in the region of $270,000, whereas the average prosecution for benefit fraud is about $70,000. And yet we prosecute 8 times as many people for benefit fraud as we do for tax fraud. And 70% of benefit fraud receives a prison sentence compared to only about 20% for tax fraud. So you can see we have these really disproportionate responses and kinds of harm, two different equivalent kinds of harm already happening in our legal system. And, you know, we don't need our legal system to be tipped even more in favor of the kinds of harm that are carried out by wealthy people, especially when it's so disproportionate to the actual harm that has been caused. You know, that there's a dollar value on this one, which is why I think it's a good example. And we don't have lobby groups sort of working to right these injustices. You know, we have People Against Prisons Aotearoa and other sort of groups like us that are largely volunteer run. But we do have very powerful, very well-resourced lobby groups that are pushing the government already in the opposite direction. You know, we have very powerful, very well-resourced lobby groups working to strip back regulation that at the moment prevents harm. You know, working to encourage the government to protect private property ever more harshly. The recent announcement of, you know, harsher punishments for shoplifting are a great example of that. So shoplifting is a crime that we already treat disproportionately harshly compared to many other kinds of harm. And that policy has come about as a result of very successful lobbying by the retail sector. You know, a representative of the retail sector has been leading a working group for the government to, you know, to look at how the government can address this kind of harm more seriously. And so we don't actually need more ability for these groups to shape our legislation. Just as an example of that, you know, 15% of shoplifting already goes to court. That's way above what you know, many other kinds of harm that are happening in our society. You know, you compare that to something like environmental crimes, environmental harms, which are prosecuted less than 0.5% of the time. You know, that's the level of sort of disproportionate action that we're taking on these different kinds of harm. So, you know, the effect of this bill to privilege within that lawmaking process all of these things that are very well protected, we think is just unnecessary and harmful. And I just want to finish by tying it back sort of a bit more closely to our kaupapa as prison abolitionists. So we already see the injustice of the status quo. You know, we know exactly how that will be worsened by this bill. So, you know, who we send to prison, how many people we send to prison, why we send these people to prison is a reflection of our legal system. It's a reflection of what we value and what we prioritize within our legal system. And it's a reflection of what kinds of harm we identify as criminal and how we enforce and how we treat that harm. So as a result of our current legal system, our prisons are full of poor people, they're full of neurodivergent people, they're full of Māori people. We have a soaring prison population. And that's not necessarily because these people have caused the most harm or the greatest harm. It's because our legal system has identified this harm as the kind of harm that we want to punish in the harshest way with a prison sentence. So the result of this bill would be to intensify that process. It will have drastically disproportionate outcomes on the working class, on poor people, on Māori. And that will result in far greater injustice from our legal system. So we think that this bill should be thrown out.
Thank you, Tom.
Yes.
Thanks, Tom. Someone who knows you well being on the Justice Committee is, of course, Dr. Duncan Webb, who's got a question.
Well, thank you for that. Look, the architects of this bill kind of frame justice as being equivalent to the protection of property rights or individual rights, and they don't kind of acknowledge the idea of redistributive justice. And I'm just really interested in your comments on conceptions of justice and what that essentially should mean from your perspective.
If I've understood your question correctly, you're asking about
let me rephrase it. There's justice which protects private property, and then there's a kind of distributive justice which tries to see rights and benefits, power distributed evenly across our society. two quite different conceptions of what justice might be. Strikes me that you're kind of coming at it from that second point of view rather than the first, and that seems to be the distinction between you and the architects of this bill.
Yeah, I would agree with that. That we definitely view justice more as a matter of sort of equity rather than equality. That sometimes treating everyone the same before the law doesn't result in actually fair or just outcomes, and that we have, responsibilities towards the collective. We have responsibilities towards each other that mean, the justice system should be about restoring the balance between people when harm has been caused. It shouldn't be about identifying, an appropriate punishment to dish out because someone has done something wrong. Hopefully that helps.
Good, no, good. You're really good, and thanks for your work as well.
Okay, thank you, Dr. Webb. We're at time, but I'm going to give Tiana Tuiono a question.
Kia ora, thank you very much for your very strong proposal. I was just sort of interested in what I thought your idea was around the privileging of property rights and individual rights, and what that would mean for the folks that you've been advocating for, those people that don't have property and have less of those things. Are you able to sort of have a comment about that around this whole lens of equity that you've been talking about?
Yeah, I mean, there's a lot to say on that, so it's kind of hard to be brief. I think housing would be a really good example, right? Like a lot of the people in prison, a lot of the whānau in prison don't have stable or any kind of housing or fair access or equitable access to housing. And a big part of why they end up in prison is because they don't have any kind of stable housing. So if our justice system, we're actually interested in achieving justice, that might be one way to go about it.
Okay. Oh, thank you. Thank you again, Tom, for your presentation and submitting again before Parliament. We appreciate your time, and keep in touch.
Kia ora.
Kia ora. Okay, we have got, who have we got next? We've got Mel queued up, according to Danella, online. Mel Mark Shadbolt. Kia ora. Welcome. You've got, we're running pretty well to time here. You've got 10 minutes. We look forward to your presentation. We invite you to introduce yourselves and allow for a little bit of time at the end, if possible, for members to have a question.
Ka pai. Kia ora, o tēnā koe e te timana, o tira ki a koutou te komiti, ko Mel Mark Shadbolt tōku ingoa, he uri au, o Ngāti Parau rātou ko Ngāti Kahanunu te aroa hoki. I'm the Chief Executive of Te Tira Whakamataki, and I'm joined by Te Taiao Moko Painting, our Policy Manager. We are a Māori environmental not-for-profit. I think we're the only nationwide Māori environmental not-for-profit. We're focused on restoring balance in Te Taiao and supporting whānau, hapu and iwi to lead in caring for Te Taiao. We are also the home of the Māori Biosecurity Network, Hono, the Māori Emergency Management Network, and Te Puna Taonga Ora Aotearoa Seed and Biobanking Initiative. We oppose the bill in its entirety because it is undemocratic, disregards Te Tiriti, and would severely weaken Aotearoa's ability to protect our environment. We, in our submission, made 3 key points. We're not going to go over all of them, but we're going to touch on them briefly, and then Te Tawatia will share how we think this will impact our work. First, this bill invites legal challenge by disregarding Te Tiriti, and for those still unclear about how it impacts Te Tiriti, we recommend that they reread and rewatch the submissions by Te Hunga Aroa and Kahui Legal. Secondly, this bill entrenches neoliberalism through the taking of property principle. Whilst Minister Seymour is technically correct that the bill doesn't create direct legal obligations, critics are also right about the practical effect. Once you embed property rights principles in legislation, corporations will weaponise them through litigation. It's kind of like creating a voluntary speed limit, technically no legal obligation, but it fundamentally changes behaviour. Treasury has already warned that the bill goes further than conventional policy and could create massive taxpayer liability. Rather than improving our economy, we believe this bill reverses the polluter pays principle and forces taxpayers to subsidise corporate profits. while still costing a minimum of 18 million annually just to administer. Thirdly, this bill threatens environmental protections. This is where our work is most impacted, so Te Taiawatia will speak to that. Finally, I just wanted to make a couple of other points before I hand over to Te Taiawatia. This bill claims to be about better policy and regulation, but New Zealand already has strong regulatory systems. We rank second globally on regulatory quality according to World Bank indicators. We have comprehensive legislation design and advisory committee guidelines, and we already require regulatory impact statements for all policy proposals already. The government's own Ministry for Regulation admits that an enhanced disclosure statement regime with enhanced obligations will achieve many of the same benefits as this bill, but with fewer costs. And as a former Deputy Secretary of a government ministry, I can tell you that quality of policy and regulation is a key priority that already exists for every senior leader across government. And ministries, agencies and departments already measure and take seriously their quality of policy and regulations. So I'm now going to hand over to our policy manager who will outline how the bill will impact our work and its real world consequences for our communities on the ground trying to protect our environment.
Kia ora mau, tēnā koutou, e te komiti. Ko Te Taiawatia moko painting tōku ingoa. I'm now going to examine how this bill would practically affect the core functions of Te Tira Whakamataki. These two examples show how its provisions would erode the tools and leadership Māori communities currently exercise. So the first is biosecurity, particularly relating to clauses 8B, 8C and 8H. Mana whenua have long used rāhui, forest closures, tikanga-based monitoring to protect taonga like kauri from disease. These responses are grounded in mātauranga and deployed with urgency and care. But even under the Biosecurity Act, we already face limitations, and rather than improving this, the RSB would compound the problem. Under clauses focused on liberty, property and legal review, essential tools like rāhui or movement restrictions could be deemed unjustified, especially if they don't meet narrow economic thresholds. That delays actions, it undermines Māori authority and shifts power to a board with no guaranteed expertise in te tiriti or tikanga. This weakens the ability of whānau, hapu and iwi to protect our forests. It breaches Article 2 of te tiriti and it leaves our whenua even more vulnerable. The second is disaster management, particularly clauses 8A, V, 8B and 8H. During Cyclone Gabrielle, many marae functioned as emergency operation centres, evacuating communities, distributing food and medical care and building flood defences. These actions were guided by tikanga and community leadership, not formal delegation. Under this bill, such rapid place-based responses could be questioned as legally or economically inefficient. Clauses on legal certainty, liberty, and judicial review could be used to challenge these vital actions. This undermines Māori-led emergency response efforts and contradicts both the Civil Defence Emergency Management Act and international obligations under UNDRIP. This bill is incompatible with international frameworks and constitutional visioning such as Mā Tika Mai, which affirms constitutional arrangements that both honour tino rangatiratanga and kāwanatanga. Let us be clear, there is nothing efficient about biodiversity collapse. There is nothing rational about silencing communities already doing the work. There is nothing constitutional about undermining te tiriti or waitangi. Internationally, these concerns are echoed by experts. The OECD and the Regulatory Outlook Report 2025 states regulating for the planet requires systematically considering climate and environmental aspects when making and implementing rules. Yet this bill strips regulation of those very consideration. The OECD also warns that drawing on diverse knowledge and partnerships, including with Indigenous peoples, facilitates climate resilient development. This bill narrows regulations to economic tests and excludes those perspectives. The IPBES Transformative Change Assessment 2024 confirms weaving together insights from Indigenous and local knowledge enhances strategies and actions for transformative change. Finally, inclusive, accountable and adaptive governance systems, says IPBES, are central to driving transformative change. This bill offers none of those things. If Aotearoa wants to lead globally, this bill pulls us backwards. It contradicts Te Tiriti, international law, and expert consensus. Withdrawing this bill is not weakness. It's a constitutional integrity, ecological necessity, and intergenerational leadership. Tēnā koutou katoa.
Cameron, you're on mute.
Just when I was saying lovely things about you too, Rawiri. I'm going to give you, we're on time, but I'm going to give you a question, good sir.
I'm sure you will. Thank you. Tēnā kōrua, mo e nā kōrero. Just on your impact of deregulation on civil defence and emergency response in your submission, when Cyclone Gabriel devastated many Māori communities, the recovery did not come from deregulated markets. It came from marae-based infrastructure, emergency planning grounded in tikanga and local leadership. Legislation that restricts proactive regulation in the name of cost efficiency abandons those communities to risk, hardship, and preventable loss. My question is, looking back on the devastation of Cyclone Gabriel and Te Tairawhiti, if the bill were passed prior to Cyclone Gabriel, how much more worse off would the coast be under regulatory arrangements set under this bill? And do you have any examples?
What a really reflective question. That's probably hard for us to answer, but we'll give it a go. I guess we're only using scenarios and making assumptions. We are worried that the bill was framed as a way to cut red tape and rebuild quickly, but that speed may come at a cost, as you pointed out, to long-term resilience and environmental protection and cultural processes. So I guess rebuilding in Hawke's Bay, Te Tairawhiti, you may get fast approvals for rebuilding homes and infrastructure on flood, to rebuilding those homes and infrastructure, but you may do so on flood-prone and unstable land because you haven't had the ability to do the necessary reviews that take a wee bit longer to do, potentially. I guess what it really means from our perspective is less scrutiny of environmental impacts, despite what locals know. And an example very quickly is, two examples very quickly. We know after the Edgecombe earthquakes that the age-old story is Napier was rebuilt fast because we deregulated, or the councils deregulated. Hastings took a long time because they went through the process. We may want that from from an outside perspective. We may want to say we want to be able to rebuild Christchurch quickly. That's where I'm based. But actually what we know is that sometimes cutting those corners create further issues and long-term damage. And they withhold and they exclude local knowledge. And all of us know local knowledge, whether that's Māori or non-Māori, is really important when you're thinking about climate resilience and sustainability, because locals know more than anyone what will happen to their whenua, to their waterways, when disaster strikes. And a really good example we often use, is that when Cyclone Gabriel happened, my husband, who is in search and rescue, was deployed to a community where modelling said they would be impacted, and all of the locals, including Ngāti Porou whānau of mine, said nothing will happen there. No one was deployed to Wairoa, where we know people who live there or whakapapa there know things will happen. So we do cut red tape, but we also create other issues. Sorry, long-winded answer.
Okay, we're just going to have to leave it at that. Thank you so much for your full presentation and submission, and enjoy the rest of the day. Thank you for appearing. Okay, we're going to go to Mr. McCready, is that right?
That's correct.
That is correct. Evans McCready. Okay.
He's just coming online now.
Thank you, Danella. Very good. Good afternoon, Mr. McCready.
You've disappeared. I can hear you.
Oh, okay. Well, we can see you loud and clear, so don't worry so much about me, and we can hear you and see you. So
Okay.
welcome. You've got 5 minutes, and I don't want to waste any more of it, so please proceed.
Okay, thank you. I support the Regulatory Standards Bill 100%. We need to enhance parliamentary scrutiny of legislation and delegated powers. The so-called mechanisms in place now obviously aren't working. Also, we need assurance that regulations are based on good lawmaking and economic efficiency. We have seen over time of problems for us from bad lawmaking. And guess who pays? The taxpayer. There isn't an economic cost to comply. We have had politicians like Mr. Jeffrey Palmer who actually believe they know best for the rest of us. Well, sorry, they don't, and the country is stuck in the mud because of it. This bill will overcome these deficiencies. Labor have years left in the wilderness because of how they have manipulated the corridors of power to their Marxist philosophies. I'll end with why can't the naysayers, i.e. Labor, Greens, give a plausible reason why the treaty should be included in the bill? Because they don't have one. So that ends my submission, and thank you.
Thank you very much, Mr. McCready. Whereabouts are you coming from today?
Manatopu in the Waikato.
Oh, very good, very good. Okay, well, thank you for your time. I can't see that we've got any questions. So thank you for your patience. Thank you for submitting to the committee this afternoon, and all the very best.
Yeah, good on you. Thank you.
Thank you, sir. Okay, that puts us on to the Auckland Action Against Poverty.
They're online with Agnes.
They're online with Agnes. Very good.
Hear me?
Yes, we can. Hello, Agnes.
Hi.
Thank you for your patience. We're just about, we're running to time almost. So you've got 5 minutes, and you've got 10 minutes at least, of course, and we look forward to it.
Okay, thank you very much. Kia ora koutou, talofa lava. My name's Agnes Maniele, and I'm here today on behalf of Auckland Action Against Poverty. A lot of my friends before me and after me will be taking the time to talk about how this bill affects their communities and the people that they serve. Today, I'm only focusing on something very simple: the people that we serve every day, the people on welfare, hardworking people, and people just trying to survive. Where I come from, no one's actually ever heard of the Regulatory Standards Bill to work. They're too busy trying to live. They're too busy trying to survive. They're working full-time, 1, 2, or 3 jobs just to keep food on the table and pay rent. Our young people, a lot of them have never heard of this bill either, but that's because they're at school, trying to learn, trying to get an education, chasing their dreams of becoming better and doing better in this world that we currently live in. But at the moment, they're dropping out of school so they can go to work to support their family, because there's just not enough to go around. This bill and many of the changes that this government has made in the past year are making things absolutely worse. You've cut funding to things that we actually need. You've made access harder to things that we need to survive. Things like food grants, things like public housing, education, and community services. These are all essential needs. And there are more sanctions, more stricter rules, and fewer support for the people who keep working, pay the highest tax rates, pay bills that keep going up and up.
all while living off the income that's not even enough to survive on. We're trying to raise our kids, support our whānau, and do right by the communities. But with these constant cuts, these constant changes, and these new laws and new policies and new legislations, they're not giving us even room to breathe. And it feels like we're being punished for struggling, and you make it as if that's our fault. But let's not forget, it was the very people, us, that you're punishing: beneficiaries, students, volunteers, essential workers, healthcare workers, caregivers, cleaners, supermarket staff, bus drivers, our elderly still working at petrol stations, construction and labour roadworks, that kept this country going during COVID. Our teachers, our churches, our service organisations and our communities all came together and held it together while everything around was falling apart. And now this government is turning its back on the very people that kept this country functioning. And the truth is, without the people, this government would have nobody to govern. So I have to ask, has this committee thought about how this bill is going to affect people on benefits and working, who depend on clear and fair rules to get housing, healthcare, and income support? Has this committee looked at how this bill is going to affect volunteers and community groups that are already working hard to help people when the government support falls short? Has this community, do you even understand that many rules to protect them from unfair treatment? I know this might be a little bit, might be a bit much for a lot of you, because I see some of you looking away as I'm talking, but this is our reality. And that's why I'm here, to stick up and stand up and talk on behalf of our people. So whether you want to turn your head or not, that's entirely up to you, but I'm still going to stand here and talk. This bill makes it harder for future governments to protect things that we need, like public health, the environment, Māori rights, and especially our human rights. It says the law needs to treat everyone the same, but that's not how you're treating our people. Some of us, yes, need more support, not less. So I'm here today on behalf of AAAP and on behalf of our people, that we don't need more rules. We actually need a government that cares about everyone, all Pasifika, all Māori, all Asian, non-Pasifika, non-Māori, non-Asian, everyone. We need policies that protect our people. We need support for our communities, and we need real change, not more cuts. And I ask you, please listen to the people who are doing it tough. And please don't make our lives even harder. Stop ignoring the voices of the people who are telling you that to stop and who need help. People like the beneficiaries, working people, volunteers, our kids, our communities, because we will all remember that. And come the next election, we'll make sure that this is a one-term government. Ngā mihi. Thank you.
Okay, thanks, Agnes. We've got a couple of minutes for questions. I'm going to go to Andy Foster, who we haven't heard from today. Andy.
Yeah, look, thanks, Agnes. Thanks for what you've just been saying. Can you, though, point me to the bits of the bill or the elements of the bill which you feel would make things worse for all of the people you're talking about? I hear your message, but I'd just be really keen to understand the link between that and the bill that's in front of us.
All of it, Mr. Fostera, all of it. There is nothing in that bill that's even going to help and support people like myself. We're not rich. We don't come from wealth. We have to live every day by working hard to put food on our table, to be able to take our kids. Things like healthcare, some people can't even afford to go to the doctors. So if you're asking me which parts of the policy, it's all of it. All of it.
Okay.
Honest to God, I don't know if that's something that you will understand, unless some of you have actually lived in poverty before. I don't think that's something that you guys will ever understand.
Okay, thank you. I'm going to go to Tiana Tuiono.
Kia ora, Agnes, and Whakatau Tira Lava for your strong presentation. And thank you for bringing that perspective to the attention of the committee. I was wondering if you heard some of the earlier contributions around the impact of when we emphasise individual rights and property rights, and how that will impact on those who don't have so much property. And I wonder if you had a comment on that.
Sorry, Tiano, I didn't actually have time to sit in beforehand. So I've been at the office all day advocating, and we've had a lot of whānau coming in today who've had their benefits sanctioned, and also quite a few whānau today that are homeless. So that's the priority. My priority for today was to actually help those people, and I only literally just logged in a few minutes beforehand. But yeah, so sorry I won't be able to answer that for you, Tiano. Yeah.
Okay, thank you.
Okay, that's all right. It gives Rawiri Waititi a shot. Rawiri, quick question.
Kia ora, Agnes. Ngā mihi nui ki a koe I tēnei rā. Thank you for your presentation. Now, AAAP does not support this bill, and that was made explicit in your submission.
That's right.
Can you give us an example of how this bill may exacerbate homelessness specific to Tāmaki Makaurau? Because I know that is the space that you guys work really, really hard in.
Absolutely. So it's hard enough to be able to try and get access into any housing. Currently, the policies and the legislations that we have with MSD and with private housing, and that makes it harder for our kids to get in, because there's so many different rules, so many different criterias. But and this bill, what it's going to do is make it even more harder for them to be able to get in. But not just that too, Rawiri. You know that some of our people have a lot of ma and a lot of shame to be able to access that kind of thing. This is why AAAP is here, because they come and see us knowing that we help. No questions asked, no judgment. This bill is actually going to cut that kind of service that we already provide out there with other organizations. And our rangatahi are not going to be able to go anywhere, nowhere. And honestly, the last resort is going to be living in the cars and living on the streets. So that's how this bill is going to make things absolutely worse for us. And at the moment, as you all know, and I'm sure you all watch the news and see what's going on, homelessness is huge. It's a big issue. Massive issue. This bill just makes it even more worse. Soon we're going to have not just homelessness, we're going to have people dying on the street, and we have already. So if you want to know how worse this bill is going to make things, that's how bad things are going to get.
Okay, we'll just have to leave it there, Agnes. Thank you for the work that you do at AAAP. All the best for the rest of the day and the rest of the week. Thank you for submitting and appearing before the committee this afternoon.
I appreciate your time. Thank you all.
Thank you. Okay, members, that takes us to St. Peter's on Willis Social Justice Group.
They're here in person.
Very good. Okay, thank you for coming into Parliament this afternoon. We look forward to your 10-minute presentation.
Thank you, Mr. Chairman, for providing the opportunity to make an oral submission. My name is Gail Duncan and I chair the St. Peter's on Willis Social Justice Group, a committee of St. Peter's Anglican Church, Tira Wellington. The Social Justice Group expresses the social justice mission of the Church by advocating for measures promoting equity, especially in defence of the last, the least and the lost, including the vulnerable, our essential workers and carers, striving to safeguard the integrity of creation and sustain and renew the life of the earth. We oppose this bill as there is nothing in the bill to support the development of a fair and just society. It offers no means to address inequality arising from asymmetry of power that currently divide society. It promotes inequality and the degradation of the creation that supports life on this planet in favour of increased economic benefit. Clause 8A3, every person is equal before the law. On these grounds, the bill could be used to remove any law that provides targeted relief or funding on the basis of differential treatment. It could be used to justify removal of programs for women, people with disabilities, Māori, Pacifica, Asian, children, migrants, and the rainbow community, and the homeless. Moreover, this legislation would hold future generations hostage. Measures that they may wish to introduce in order to protect the environment or vulnerable populations would be restrained by the potential for claims of damage to private property interests. The proposed legislation is contrary to the Christian gospel and inconsistent with Te Ao Māori, Pacifica, and Asian traditional values. I would like to take a moment to compare the principles of responsible regulations with 3 of the worldwide Anglican Communion 5 marks of mission. These 3 marks of mission are: Pillar 1, to respond to human need by loving service. Pillar 2, to transform unjust structures of society, to challenge violence of every kind and to pursue peace and reconciliation. Pillar 3, to strive to safeguard the integrity of creation and sustain and renew the life of the earth. The Social Justice Group of St Peter's on Willis considers that these 3 marks of mission provide a much better definition of the principles of responsible regulation than those proposed in Part 2, Subpart 1, Principles of Responsible Regulation. These 3 marks of mission allow for charity, compassion, and recognition of the need to address manifest injustice created by asymmetry of power. Communities have been slowly chipping away at the power seized by property owners centuries ago. Universal suffrage was a major step in reducing the asymmetrical power of property owners, which they had preserved by limiting the democratic rights of citizens. Environmental considerations, employment rights, and worker safety concessions are all hard won. The transfer of power in these areas away from property owners has benefited society as a whole, including businesses. The Social Justice Group sees the Regulatory Standards Bill and the Regulatory Standards Board as an overt move to seize back and re-establish the asymmetry of power that property owners historically wielded. This bill represents the latest step in a lengthy battle by the ACT Party to codify their view of principles for good lawmaking and economic efficiency. The new bill seeks to establish an independent but unelected statutory board with the power to scrutinise both existing and proposed legislation. Every future law from 1 January 2026 and retrospectively all our current laws from 1 July 2026. Every law ever passed in New Zealand. Impossible and expensive. And this is a fundamental constitutional shift, undermining how our society operates, undermining our democracy and our social contract, including Te Tiriti. It is not a simple matter of monitoring compliance and enforcement of new regulatory standards to ease pressure on business. The Takings Clause 8C indemnifies monopolies from the loss of their monopoly rents as part of pro-competitive regulations and requires the Crown to compensate for any losses arising from regulation. It is a giant tilt of the playing field towards entrenched commercial interests and will have a chilling effect on government legislation. Fair compensation is undefined, and this is an area where we particularly see the asymmetry of economic and political power creating unfair outcomes. The criteria for appointments to the Regulatory Standards Board, Clause 38(5), are far too broad and fail to ensure that the board will be appropriately representative of community interests. Especially lacking is anyone with expertise in ethics and in te ao Māori. The Regulatory Standards Board could give too much power to corporations and wealthy lobbyists to pressure government. The balancing of interests should remain with our elected representatives. The Regulatory Standards Bill shifts power away from Parliament, whose role is to balance different interests, centering power in the Ministry for Regulation, and to the non-elected Regulatory Standards Board. The bill puts the government in a position where it cannot impose any responsibility on business for the impact of their commercial activities on the environment, social or physical. No responsibilities related to impacts of the externalities of business or private activity on society are defined. The principles of the Treaty of Waitangi Bill was defeated on its second reading on the 10th of April 2025 because it removed obligations to respect and apply Te Tiriti o Waitangi. Yet here we have in this bill a second attempt to undermine Māori tino rangatiratanga and ignore the role of regulation in protecting shared resources. We all know that deregulation can lead to poor outcomes. Deregulation and changes to the building codes in the 1990s led to poor construction materials and practices being used. Compromises in worker safety, including Pike River, underfunding of inspection and enforcement, such as Havelock North Campylobacter contamination of public drinking water. New Zealand already has one of the highest rates of worker deaths in developed countries. Deaths and injuries of New Zealand workers occur across many industries, such as forestry, construction, ports, transport, quarrying, and factories. The bill would impede government from acting in the interests of citizens regarding regulations to control practices and products that lead to poor health outcomes. Examples include air pollution, smoking, alcohol, forestry / building in public and flood zones. Government is much less likely to make bold changes to deal with climate change and major public health and equity issues. Finally, this bill, by its very nature, would impose upon Māori-led progress, both socially, environmentally, and commercially, if it is seen as blocking the potential of other businesses. The success of Māori-led initiatives increasing our GDP and improving the whole quality of our nation and our obligations to Te Tiriti could be at risk. To conclude, it is the firm opinion of St Peters on Willis Social Justice Group that this legislation should not proceed and must be abandoned at the next opportunity. It should never become part of the legislation of New Zealand. Nō reira, tēnā koutou katoa. I look forward to any questions. Thank you.
Okay. Oh, thank you very much. We're at time, but I'm going to give Dr. Russell one question.
Thank you. Look, I'm broadly sympathetic to your submission. I just wonder if you could point to specific gospel verses or passages, and I particularly mean the Gospels rather than the other parts of the Bible, that would support the approach that you've taken.
I have to admit, I can speak generally to the, I'm not a minister, to the whole of the gospel, which supports inclusion and reconciliation. So that's, but I cannot, like Dr. Bryce Wilkinson did in the Red Tape Hui, which was held at St Peters on Willis, was not intending to go through passages of reference to the gospel. Thank you.
Okay. Thank you.
Okay, thank you very much for coming into Parliament this afternoon and for submitting in person. We appreciate that. Thank you. Okay. We've now got Robbie Crawford is queued up.
Yeah, he's online.
Mr. Crawford.
Yes,
I hope we're not going to cause an accident. You're well parked up by the look of it.
I am.
Okay. No, we look forward to your 5 minutes. Thank you.
Thank you. I'll keep it as concise as I can. Tēnā koutou e te komiti, ko hikerangi te maunga, ko Iwawa te awa, ko Hawiti te marae, ko Ngāti Parau te iwi. Ko Ropata Tamati Rangi Crawford. Tuku ingoa. Members of the committee, thank you for granting me time to present this oral submission in opposition to the Regulatory Standards Bill. I speak as a practicing engineer from Uawa, Tolaga Bay, where all infrastructure must reconcile statutory requirements, community aspirations, and rigorous engineering judgment. This bill sabotages that reconciliation. An engineering regulation is the legal architecture that safeguards life. When a statute is incoherent, its consequences are not theoretical, they are physical, financial, and irreversible. The bill before you is not only very poorly drafted, it is structurally contradictory, constitutionally evasive, and operationally corrosive. Any law is only as reliable as its internal logic, yet this bill defeats its own stated claims. It proclaims liberty, property, equality, and clarity, only to strip those very principles of enforceable effect in subpart 5 of this bill, rendering the constitutional frame purely theatrical. It establishes a compliance pathway that begins with ministerial certification, proceeds through departmental drafting, and ends with review by a board appointed by the same minister, institutionalizing executive capture under the guise of oversight. It relies on operative phrases, reasonably practicable, unduly diminished, as soon as practicable. They remain undefined, facilitating discretionary interpretations immune from judicial scrutiny. It lauds universal application, yet empowers the minister to exclude entire classes of law, treaty settlements, defence matters, by simple notice, ensuring discretion swallows principle. It mandates publication of accountability statements while guaranteeing, again, in subpart 5, that breaches carry no legal consequence, offering visibility without redress. The contradictions deepen. While professing a deregulatory posture, the bill arms its Regulatory Standards Board with intrusive powers to compel information from public bodies, private entities, and iwi organisations by court order, transforming libertarian rhetoric into a surveillance mechanism. It invokes the courts in Clause 8G, yet elsewhere denies them authority to interpret or invalidate legislation on the basis of the bill's principles, simultaneously citing and silencing the judiciary. It imposes a duty on agencies to review laws for consistency, but allows the minister to nullify that duty by withholding a Gazette notice, placing scrutiny in the hands of the very party subject to review. It affects ideological neutrality, yet embeds an overt libertarian bias that elevates tax restraint, deregulatory preference, and property absolutism, while granting no comparable weight to environmental stewardship, distributive justice, or Te Tiriti o Waitangi. It declares parliamentary supremacy in theory while eroding it in practice. Accountability statements are not debated. Board reports float to the minister rather than the House, and exemption decisions occur wholly outside parliamentary process. Together, these provisions construct an architecture of appearance over substance, each subpart gesturing toward principle only for that principle to be nullified elsewhere. For engineers, this is not abstract. It generates a regulatory environment where statutory obligations lack internal coherence, exposing critical infrastructure projects to shifting interpretations, retrospective justifications, and politicised scrutiny. In fields where safety margins are not theoretical, where a clause can mean the difference between resilience and failure, such an instability is unacceptable. The bill undermines the regulatory certainty required for our engineering profession, our professional accountability, It distorts risk allocation and corrodes the very legislative framework intended to safeguard life, property, and the environment. As set out in my written submission, this bill jeopardizes the conditions under which sound engineering decisions are made with clarity, consistency, and accountable statutory authority are prerequisites for safe and resilient infrastructure delivery. I therefore urge the committee not merely to revoke this bill, but to dismantle its architect's underlying ideological architecture in full. A statute that nullifies its own principles, evades judicial scrutiny, and dislocates responsibility from elected representatives cannot credibly serve as the foundation for lawful regulation. When coherence is abandoned, when accountability is structurally displaced, and when parliamentary sovereignty is subordinated to an unelected, ideologically configured board, this is no longer reform, it is constitutional subversion.
Okay.
Rejecting this bill is not, about to finish last line, rejecting this bill is not an act of political resistance, but an act of constitutional stewardship. It is necessary obligation to uphold the legitimacy of regulatory governance to defend the sovereign authority of government and to honour the democratic and treaty-based compact that underpins lawmaking in Aotearoa between Māori and the Crown, between people and the Parliament. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa.
Oh, kia ora, Mr. Crawford. That very well articulated. I can imagine some of your car trips would be pretty intense.
Especially when I have my dog with me.
we haven't got any time for questions. We're over time, but thank you for submitting to us this afternoon.
Thank you very much.
Okay, all the best. Thank you.
You too.
Okay, Danella, that takes us to Peace Action Otahi.
We don't have them online yet, but we have the Niue Group.
Okay. Do we have the Niue Group?
Yeah, we'll promote them now.
Yeah, let's go straight to the Niue Group.
We are.
Oh, very good. Oh, wow. That's brightened up our afternoon already. Thank you. You've got 10 minutes. Thank you for jumping the queue there and being prepared. We look forward to your presentation. We're in your hands.
Oh, thank you. Whakalofalai atu ki matolu osi. Our greeting in Mangaho Niue and that of our Moana Nui family across our great ocean, the Moana, are greetings that are based in Alofa. I'm speaking as a Niuean, born in Niue, but raised here in Aotearoa. I have a PhD in sociology from the University of Auckland. I'm representing a collective of Niue and non-Niue scholars, activists, artists, and descendants of Niue and the Moana Nui region. The people of Niue and the Moana Nui have strong historical and ancestral links with Māori, Tō Tangata he Motunui. Our common ancestors are Tangaloa, Maui, and Hina. Many of us have children and mokos with Māori ancestry through intermarriage. As a collective, the Niue Group opposes the Regulatory Standards Bill and see it as yet another attempt to undermine Te Tiriti or Waitangi, the founding document of this country. New Zealand has a unique relationship with peoples of the realm of New Zealand nations, the Cook Islands, Niue and Tokelau, through constitutional arrangement. The relationships was institutionalized by successive New Zealand governments when Pacific was appended to Māori as colonial territories of New Zealand, and later as Pacific peoples began to arrive in New Zealand. From the 1950 onwards, the Department of Māori and Island Affairs was the initial public sector bureaucracy. Our ancestors came to hold up the New Zealand manufacturing industry. By appending us to Māori, we were subjected to the same paternalistic benevolence of the state. Our experiences in and of New Zealand has taught us that the discourses that shape government directives and practices in respect of Māori will impact us. We do not feel the trickle-down effect of wealth to the poor, but we feel the trickle-down effect of Māori gains and losses. We have seen the cutbacks in the public sector and funding streams to support our initiatives to revitalise our realm languages and strengthen our education and health outcomes. We still die young in this country. We have heard the sponsor of the RSB make negative public remarks of the Ministry of Pacific Peoples, and more recently of academics who do not agree with the RSB. Who is managing the conflicts of interest of the sponsor of the RSB? Our history tells us to be wary of the New Zealand government and its empire and paternalistic tendencies. In 1900, the New Zealand government annexed Niue without informing the natives. Again, in the 1960s, the New Zealand government began the decolonisation process of its colonies without informing the natives. The Niueans first heard of it via a radio broadcast, but our ancestors stood ground and held off its decisions until 1974, when Niue finally conceded that it would become a self-governing state in free association with New Zealand, conditional to retaining our New Zealand citizenship and economic support of Niue. Will the RSB give power to the minister to meddle in the constitutional arrangements made in faith by our ancestors? We believe that it will. Given our historical and current experiences in and of the New Zealand government and the treatment of Māori people and the undermining of Te Tiriti has taught us to be alert, participate in the democratic process and support Māori. The implications of what is happening in New Zealand to Māori has not gone unnoticed across the Moana Nui. We have seen the fallout of the relationships between New Zealand and the Cook Islands and Kiribati. The fallout with the New Zealand government in the public arena reminds us of the tenuous position of realm nations. It reminds us who has the purse has the power. It is not us. It is not the Tiriti partner Māori. There is a disquiet in the Moana Nui. We reject the RSB in its entirety because it fundamentally breaches Te Tiriti o Waitangi and undermines the treaty principles of tino, rangatiratanga, and partnership. It is not a partnership if one partner requires a security escort to present an oral submission to a parliamentary select committee because of the actions of the other party. The idea of formal equality being touted in the RSB, that is, everyone is equal before the law, ignores the current inequities in health, education, and social and economic outcomes faced by Māori, Raum, and Pasifika populations. There is no even playing field out there. It is a myth carried in the baggage of colonial settlers and institutionalized in its structures and systems. Finally, we stress the RSB gives unprecedented powers to the sponsor of the bill, the current Minister of Regulations and his board, institutionalizing the principles of a political party into the constitutional fabric of New Zealand and centralizing power in one person's hands or board is unprecedented in this country. We are seeing this in action currently when the Deputy PM, Minister of Regulations and sponsor of the bill is being intentional in his targeting of academics and lawyers who oppose this bill. Parliament has become his high school yard. Whakaoe for the opportunity to give voice to our written submission. I think I might have used up all my 10 minutes, Chair.
Well, you're just inside your 10 minutes, but it will give one of our Pacific champions in Parliament, Tianao Tuioni, an opportunity to have a question.
Okay.
Kia ora nui and whakalofalei atu mautolosi. And thank you very much for painting that picture of the situation in the realm and also the relationship between tangata whenua and tangata moana. And I wondered if you could, for the committee, talk about maybe one aspect of how it could impact people in Niue, so possibly educational health, if this bill would go ahead.
Well, I think, you know, as I said in my submission, lots of things are happening, and we're wary at the moment because if someone has the power to regulate this country, you may wake up one day and see that the minister has decided that he'll meddle in the constitutional arrangements of Niue. And so this is what we're really concerned about, because we have a historical history of New Zealand not being really great, but we can see its responses to New Zealand Māori. We are looking, we are watching, and so these things teach us to be alert. And so if the RSB does become law, you know, what's to stop people meddling in those constitutional arrangements? Nothing really. We've seen it in practice here, in the cutbacks, and the way that people talk about the Ministry of Pacific Peoples. They can talk about that ministry here in New Zealand. What are they saying about the realm countries, for example?
Okay. Thank you very much. Thank you for your 10-minute presentation, and thank you for the scenery as well. We've enjoyed that, especially as the temperatures seem to be dropping here in Auckland. Thank you. Who have we got next? Have we got elements of resilience?
Yes, they're online.
They're online. Okay, we're on the back straight, members, with 5 submitters for today left.
Hello.
Hello. How are you, Zainab?
Good afternoon.
Very good. You've got 10 minutes here, and we look forward to your presentation. We're in your hands. Please leave us with a couple of minutes at the end for some questions if members want to ask them.
Tēnā koutou katoa, kua hui mai nei ki tēnei kōrero I ngā kaupapa o tēnei rā, ngā mihi kia koutou katoa. Hello and greetings to the member of the committee and of course anyone else attending this gathering. I'm going to start off and be very honest. I'm not bringing any new arguments to the table today. I oppose this bill and have shared my arguments in the written submission. However, I'd like to take the opportunity this afternoon and ask a few questions because supposedly this bill is just a mechanism to improve laws and the lawmaking process. However, if that were the case, then surely there would be room for criticism, feedback, expressed concern, and to help improve this law that is supposed to improve all other laws, right? If this bill really were common sense, as we are led to believe, then I am left wondering why has it been defeated 3 times prior? If there is so much trust in this bill that it will stand up to any scrutiny, then why does this bill need to be rushed through the submissions process as well as the select committee process? If this bill is to be of such great benefit to us all, then why are the people like myself who made an effort to comment on the bill brushed off as bots? Why is it that the minister ignores the advice from his own ministry on this bill in addition to ignoring the multitude of objections from all kinds of organisations and institutions? And how come the critics of this bill are exposed to character assassinations by way of being called victim of the day and other harmful attacks? Why are they not presented with strong counter-arguments against their criticism? So all in all, these questions and the overarching process makes me wonder, is this really just a bill that aims to improve the laws and lawmaking processes, or is there more at stake here? So I'd like to reiterate, and I want to leave no question that I oppose this bill in its entirety, and I believe the Regulatory Standards Bill or any other variation of it should not be passed into legislation. I hope the Select Committee will take my questions into consideration moving forward. And having said all this, I would like to end with a whakatauki, or a Maori proverb. Hei taonga nui te tūpato. Caution is highly prized. Nō reira, tēnā koutou, tēnā koutou, tēnā tātou katoa. Thank you for your time and allowing me to speak here today so far.
Oh, thank you very much, and thank you for leaving plenty of time for questions. I'm going to go to Dr. Duncan Webb.
Good. Thank you, Xander. Very quick question. What do you think the purpose of this bill is?
So what I understand from it is, as I said in the questions, is that it's proposed to be a law, a legislation that's going to help make more efficient and have an influence on all the other laws that are going to be made going forward, as well as the possibility to have an impact on the previous laws that have been made.
I guess my question is, though, that's what it's ostensible. That's what kind of the name is on the tin. But do you think there's something else going on here?
Yes, I think there's more at stake than just a law that is supposed to, as I said, make the future laws and past laws more efficient, or the lawmaking process more efficient.
All right, thank you.
Okay, Andy Foster.
Yeah, look, thank you very much for that. You said two different things at the beginning of your submission. You sort of said, well, ostensibly the bill's about improving legislation, but then you said that there seemed to be a reluctance to take any criticism of the bill or suggestions for amendments. And then you said at the end, look, I reckon the whole thing's a terrible bill, and throw the whole lot out. So what I'm going to do is invite you just to say, are the bits of it, if you said, look, the principle is we're trying to get the best possible legislation generally, and this bill's supposed to be about helping that, whether it achieves that or not is another matter, but this bill's about helping it. What are the elements of the bill that you would say, actually, no, you need to change that, and that before it becomes a bill which actually does that and doesn't have some other adverse effects that are obviously feared by quite a number of submitters?
Yep. I think that's a big question to ask from me. I feel there's been...
I know you can handle it.
Yeah. Well, I think with regards to feedback to make the bill more sound or better going forward, I'd say I think the people that have spoken out about the bill and have more knowledge in areas of legislation and lawmaking and those kinds of things, and have suggested amendments and those kinds of things, I feel they should be listened to rather than myself in this instance.
Very good. Any other questions, members? Xander, have you got any closing remarks, given that you've been so generous with your time?
Yes, I thought I'd try and keep it as short as possible. Must be a long day for you all. I think this is all that I wanted to share with you today.
Okay. No, that's very good. I will thank you for joining us, and thank you for your interactions, and we appreciate you appearing before the committee today.
Yes, thank you all, and have a lovely rest of your afternoon.
Same to you. Thank you. Okay, that takes us, we're running slightly ahead of time. Greenpeace Aotearoa, are they queued up, Danella?
Yes, they're here in the room with Jiddi too.
Oh, very good.
Tēnā koe, Mr. Chair. Tēnā koutou e te komiti.
Thank you. Yes, please proceed. I can't see you just yet, but you've got 10 minutes, and leave us with a bit of time for questions if at all possible. Welcome.
Thank you, and thank you for the opportunity to present today. My name is Genevieve Toop, and I'm here submitting on behalf of Greenpeace Aotearoa. We submit in opposition to the Regulatory Standards Bill and ask that the Select Committee reject it in its entirety. Greenpeace has operated in Aotearoa since 1974, decades before the Business Roundtable began promoting this bill. And tomorrow marks the 40th anniversary since our flagship vessel, the Rainbow Warrior, was bombed in Auckland, killing Fernando Pereira. This tragedy became a defining moment for New Zealand. In its aftermath, we stood up to global superpowers and declared ourselves nuclear-free. And in doing so, we showed the world we are a nation that defines ourselves by the values of fairness, justice, and collective responsibility to protect people and the environment. The Regulatory Standards Bill goes against all of those values, and it is our view that the bill represents an unprecedented threat to the environment. In the remainder of this oral submission, I will explain how the bill does this. But before I do, Mr. Chair, I would like to reference your maiden speech, in which you said, "We will dig deep to deliver the New Zealand our children and grandchildren deserve, the greatest country on earth and a place where hard work is rewarded." That is a positive vision, Mr. Chair, and many of us would agree with it. However, if the Regulatory Standards Bill is passed, then the digging deep that will be happening will be deep into the pockets of the public. And their tax dollars will be used not to reward hard work, but to reward wealthy multinational corporations that are polluting our water, our environment, and our climate. Clause 8C of this bill reverses the well-established principle that polluters should pay for the harm they cause, not be paid. Instead of basing laws on values of fairness and collective responsibility, this bill deliberately misuses the language of freedom and liberties as a cover for the dangerous and fringe idea that individuals and corporations are entitled to harm nature and others. And if we, through regulation, try to stop them causing that harm, then we should have to pay them compensation. The list of principles in Clause 8 of this bill elevates individualism and corporate property rights above the rights of people and nature, above the collective public interest, and the protection of the environment which sustains us. And instead of justice, which demands that the Crown honour the treaty that it signed, this list of principles in the bill does not include our founding document, and in doing so, it attempts to sideline it from future lawmaking. These principles are based on extreme ideas that I argue have no place in our democracy here in Aotearoa. Clean water, safe food, and a livable climate should never be made subservient to the so-called property rights of corporations. And I am deeply troubled that I'm having to restate the basic principle that polluters should pay, not be paid. At stake with this bill is the ability of future governments to respond to the very real crises we face: climate change, inequality, biodiversity decline, without being tied down by new bureaucratic hurdles, corporate compensation claims, and the ACT Party's rigid neoliberal ideology. I'm here representing an organisation with decades of expertise in environmental issues. In 10 minutes, I can't explain to you the myriad of ways in which humanity is utterly dependent on the environment, but I will say this: the water that comes out of your tap every day comes from the environment. And whether it is clean and safe to drink depends precisely on whether the government has done its job, regulating the activities that companies carry out using their property. The food that you eat is provided by the environment, and its production is dependent on a stable and hospitable climate. And on that front, we are swiftly running out of time. The climate is becoming more and more hostile to food production and to human life. Last week, flooding destroyed homes in Tasman. Last year, it was in Dunedin, and the year before that, it was in Auckland and Tairāwhiti. Instead of helping communities recover and adapt to these climate disasters, This bill opens the door for fossil fuel companies like Shell and ExxonMobil to demand financial compensation from the very people suffering the impacts of climate change. I would like members of this committee to consider the question, is that fair? And for those members considering voting in support of this bill, are you ready to explain to every hardworking, underpaid woman in New Zealand that this government couldn't find the money to pay equitably and fairly? How exactly is it fair that this government is considering passing a bill that puts the taxpayer on the hook for potentially billions of dollars that will be expected by these multinational polluting corporations and their offshore shareholders? If you still cannot see the deep injustice that is hardwired into this bill, or you don't believe Greenpeace when we say it represents an unprecedented threat to the environment, then I would refer you to the Ministry for the Environment's advice. The Ministry has called this bill deeply problematic. It has warned that key aspects, quote, conflict with the fundamental principles of the environmental management system, posing risks to the health, safety, economic, social and environmental interests of current and future New Zealanders, end quote. Regulatory environmental protections and climate measures are necessary, and by their design, they will conflict with the principles in this bill. They will inevitably place limits on how corporations can use their property, and they must, because it is precisely the underregulated and inappropriate use of property by companies that have created the multiple environmental crises we're facing. David Seymour claims this bill isn't enforceable in the courts, but if it passes, every future minister who wants to pass regulation that puts people's interests, the environment or the treaty first above corporate property rights, that minister will face two choices. They can either scrap the regulation or publicly justify why it defies David Seymour's ideology. The bill even creates a corporate complaints board, an unelected regulatory standards board, which will be empowered to hear and amplify the complaints of corporations and challenge laws those corporates don't like on their behalf. And this bill hands extraordinary powers to its author, David Seymour, who will decide how the principles should be applied, who should be consulted, and who sits on this unelected corporate complaints board. This is David Seymour trying to make himself the Lord of laws, to which every minister will have to answer to. And I can't understand why on earth national and New Zealand First Ministers or aspiring ministers would ever want to hand that much power to the leader of a far-right minor political party that received just 8% of the vote. By this point, you've now heard from doctors, constitutional experts, environmental scientists, Māori academics, business leaders, and multiple government departments opposing this bill. They've warned of serious impacts on New Zealanders' health, the health of our environment, Crown-Māori relations, the list goes on. And any MP voting this bill through its second and third reading must at this point know that they are doing so with the full knowledge that it will be deeply damaging to Aotearoa and its people. And again, I am deeply troubled that I'm having to restate core values I thought we all held. That in a democracy, the government is supposed to serve the people, not corporations or the interests of a handful of wealthy elites. This bill is unworkable, untenable, and unwanted. I implore the Select Committee, reject it in its entirety, and instead focus on building an Aotearoa that is fair, just, and grounded in our shared responsibility to protect people and the planet and honour Te Tiriti o Waitangi. Thank you.
Oh, very good. Very good. Okay, we're going to go to questions. I was going to move an extension of time when you started quoting my maiden speech. That was a good start. But I'm going to go to Andy Foster first.
Yeah, look, thank you very much for that. You particularly quoted Section 8C of the bill, and which says that legislation should not take or impair or authorise the taking or impairing of property without the consent of the owner, and then unless you compensation, etc. Just wanted to know from you what you consider impairment to being, because to my understanding, there is no property in the entire country that you can do with exactly what you like. They all have restraints on them in terms of environmental legislation, Resource Management Act, district plans, national standards, and so on. Would those, in your view, constitute impairments?
Well, thank you for the question. I think what you've highlighted there is a core problem with this bill, that not only is property not defined, nor is impairment.
No.
And it does not outline in the bill what fair compensation is either. And in this bill, it says that David Seymour, the Minister for Regulation, will offer the guiding principles for how the principles in this bill, including Clause 8, would be applied. So it hands a huge amount of power to one minister to decide what is property, what is the impairment of that property, and what is fair compensation.
Thank you.
Okay, no, that's good. Thank you, Andy. Tiana Tuiona.
Kia ora, kia ora. Thank you, Jen, for spelling it out really, really clearly. And let me also acknowledge the anniversary of the bombing of the Rainbow Warrior, which will be happening tomorrow. Ngā mihi kia pui o tira kia koutou katoa. I was wondering if you could paint us a specific picture in a particular aspect of how this could negatively impact the environment in particular. So, for example, maybe it's mining, maybe it's ocean health, just to give the committee a specific picture of your concerns. So I agree with what you've said around the absolute dangerous nature of this bill as well. And if we had some specifics, maybe that would bring it home for some of the committee.
There's so many examples I could give you, but I will go with oil drilling, because this government has attempted to reverse the ban on deep sea oil drilling in New Zealand. And if a future government decided to regulate to prevent a catastrophic oil spill, like the one we saw with the Deepwater Horizon in the Gulf of Mexico, that devastated the fishing industry in that area, that devastated the environment, if the government chose to regulate to ensure a catastrophic oil spill like that did not happen in the oceans of Aotearoa, then the companies oil companies who have property here in New Zealand, whether that be an oil rig or a permit, could potentially argue that they should be compensated just for the regulation that would protect us from a catastrophic oil spill. And not only that, the minister wanting to do that regulation would have to publicly justify why it is potentially impairing the use of an oil company's property. And what we see is that this bill will cause a chilling effect on beneficial regulation that is required to address the multiple environmental crises we face.
Okay, members, I think we've exceeded our time and our conversation there has been extensive. So thank you so much for coming into Select Committee Room 4 today and presenting your submission before the committee.
Thank you.
Thank you. And Tiana, thank you for alluding to the fact that the Rainbow Warrior 40th anniversary is tomorrow. It's interesting, I'd never put the two, but Live Aid, the 40th anniversary, is on 3 days later. So that all happened within a few days, those global events that we remember. Okay, Richard Northey, have we got Richard online?
He's online now.
Oh, very good. I'm going to give you an introduction, Richard, because we've got a little bit of time and you won't be able to interrupt me. Now, Richard, great to have you here. Richard is one of our, many of you will know, but Richard, of course, is a local government and central government luminary. He was someone who actually served as a young councillor under Sir Dovemire Robinson. And of course, he was in that fourth Labour government. He was there when the Rainbow Warrior sank. And he continues to serve on the Waitemata local board. So I would say that you're one of the longest serving public elected servants in New Zealand at the moment continues to hold pretty senior positions. So welcome, Richard.
Well, thank you, Chair Cameron Brewer and honourable members. Yes, I've only been an elected member since 1979 when I was elected to the City Council under Dovemire Robinson. You've got my submission. I'll just highlight some points. The establishment of a regulatory standards board appointed not by a consensus of members of parliament, instead in an undemocratic way, entirely appointed by the Minister of Regulations, could end up with those views creating an echo chamber rather than a check. And it also diminishes the accountability of the elected organisations that are currently responsible, including the Executive Council, the Regulations Review Committee, and the boards and councils delegated by an elected parliament to make regulations. The list of principles as set out against which legislation and regulations are proposed to be assessed is inflexible, incomplete, and prioritises important individual and property rights over a number of at least equally important rights of the nation as a whole and of important communities within it. When I chaired the Regulations Review Committee, we developed in a multi-partisan way a series of important tests and criteria for assessing regulations which were being or could well be challenged. Parliament and other lawmaking institutions need the flexibility to change the priority of the principles and criteria applied with changes in technology, the economy, the environment, the political culture, values, and understandings about rights, and not, for example, be stuck with excessive rights and priorities for, say, gun owners in the form of a militia in the US, when the threat from King George has surely long gone. The list of principles proposed to be applied is too rigid, unbalanced, and incomplete. I've suggested some others of at least equal importance, but I believe that they should not be listed there. They should be up to Parliament as representatives of the people to decide what are the priorities and how they should be applied. Parliament's individual and collective principles and criteria need to be able to adapt when the world, the nation, and its needs, priorities, and beliefs change in order to be able to respond appropriately and effectively to new challenges and opportunities. The Regulatory Standards Bill should be rejected in its current or any amended form. Thank you.
Thank you very much, Mr. Northey. Have we got any questions, members? Any comments, any observations?
Just from me, if I may.
Yes, Dr. Russell.
Yeah, Richard, you've got an incredible amount of experience to bring to this submission, so thank you for doing that. I mean, you said reject the bill, but do you think there is a need to look at the quality of regulation in some way, and are our existing systems adequate for that if they're enhanced?
Well, I found the Regulatory Regulations Review Committee a very useful way of doing that and establishing new criteria, such as the need to consult with the white baiters, which then became a criteria which was utilised subsequently. So there needs to be a committee of parliamentarians that is effective at checking these things, and as an appeal body, as it acted on response to requests, and obviously there's also the courts to a degree. But I think as long as there's time allowed within Parliament to be able to reflect on where we're heading in terms of regulations, the sort of to check the sort of principles which we applied 30 years ago were whether it was appropriate. Is a regulation the most effective and appropriate way of dealing with it? Or it should be education, fines, or primary legislation. Clarity, is it quite clear to anybody that what the policy, and does it fit the policy it's meant to be implementing? Whether it's proportional, whether it's fair and just, and whether it's consistent not only with the rights of individuals, but equally to collective rights and to treaty. Those are the sort of things, and the priorities among those will change in a crisis. Some will become more important than others. But I think the thing should be with elected representatives rather than a body appointed by one minister.
Thank you.
Okay, we'll leave it there, Richard. Also good to see Mrs. Robin Northey in the background there, and who's had equally a long life of public policy and public service. So great to see you both, and thank you again, Richard. Right, that takes us to Rimu. Have we got Rimu on board?
Yeah, she's online now.
Oh, welcome. We're running straight to time, and so we welcome your 5 minutes. And if you can leave us with a minute or two for questions, that would be appreciated, I'm sure.
Kia ora. I hope you can hear me all right. Thank you, committee, for the opportunity to make an oral submission. I appreciate this is your last 5 minutes of the day, so please bear with me. I'm Rimu. I vehemently oppose the Regulatory Standards Bill and the ideas behind it, which I'll take my written submission as read. And I also oppose the process behind it, which I'd like to explain a little bit more now. I have a background in linguistics, which is the study of language. So to analyze the process behind this bill, I used a software called AntConc and a method of analysis called critical discourse analysis, which tries to uncover how language is used to create and maintain power dynamics in society. The aim being to identify connections between language and power. The method means that I looked at the words with critical glasses on and looked specifically for evidence of the sneaky use of power in situations where the people involved are meant to be on equal footing, those being the ministry and the submitters. I don't have enough time to explain what I found in the ministry's discussion document that the public consultation was in response to, or the bill itself. The rest assured, what I found is very similar to the document that I did focus on, which is the ministry's summary of the public consultation, which I'd expect to be representative of the data collected. This proposed bill is meant to have been amended in response to the public consultation. That's why I believed it was important to look at what the ministry said that we, the public, believe about the bill. And what I found is that they biased the report in favour of the bill and those who support it. Now, if the ministry wanted to present us a report that did that, even though the vast majority of submitters oppose the bill, what would that bill look like? Well, they'd be vague with their statistics. They'd try and convince you that support for the bill is bigger than it is. They did do this. Out of over 22,000 submissions, there were 76 total supportive. But the total number of submissions over the course of the report decreases. That misrepresents the support within the submissions. The numbers in this report don't add up, and the charts and the graphs used to represent them are also misleading, by the way. They split up the submissions by types of organisation, but they only told us how much the group that most supported the bill supported it. This presented a view that industry and sector groups support the bill. That's not true. Only 12% of those submitters supported it. That number also happens to be the exact percentage of total support for the bill as well. So 12% of 23%, 0.3%. They created a sample that they used throughout the remainder of the report and overrepresented it in favour of support. They didn't even tell us what the level of support or opposition within the sample they created was. They also used vague language. I found that the most frequent word or phrase used to describe submitters was some. Now, we all know words mean things. This one means being one, a part, or an unspecified number of something. It's subjective. When I hear some submitters, I might think 10%. You might think 45%. There is a massive, statistically significant difference between the two. This had a double benefit in favour of the bill, where 0.3% support was represented as some, you might imagine 45%, and the massive 88% opposition, well, you might think 10%. And the fact is, they didn't clarify or give us the numbers. So how are we supposed to trust any of their framing around what the supportive submission said? Things like the bill reduces the likelihood of unjustified regulations and overregulation. Subjective claims. Who decides what's unjustified? David Seymour, the Minister of Regulation? Sound legislation requires evidence. Phrases used throughout the report like a common perception, adequately, and seen as lack empirical foundation. While these 76 supporters might have had examples for their individual lives, that's a very different thing to representative experiences. If we can't trust the summary of the one public consultation by this ministry and minister producing this draft bill, how are we supposed to trust them with the immense power that this bill would give them? This law privileges one ministry and one minister, the ACT parties nonetheless. And at the end of the day, do you really want that? I understand you have the right to improve it. I'm asking you don't. You know better. Improving this bill would be like putting a cherry on a pile of dog excrement and calling it a sundae. It's okay to change your minds when you learn information, new information. Please do so. Don't allow this bill to proceed and speak up against it in your caucus. Thank you. And apologies, I don't think I've got time for questions.
Maybe just one.
Thank you, Rimu. That was some analogy, and I'm going to give it one question and to Dr. Deborah Russell.
Oh, Rimu, thank you. We've heard from a lot of lawyers and constitutional experts, so it's great to hear this different sort of expertise being brought to this bill. Given your concerns about the way those submissions were analysed in the January round, the ministry here is elected with some protest, I'm going to use that word some, from MPs to use artificial intelligence to analyse the submissions on this bill. Do you have a reaction to that?
I think that it is an utter shame that a new ministry with new staff that have been hired, public servants with salaried incomes, are using a large language model and artificial intelligence that hallucinates. It just hallucinates most of the time in the right order. None of what artificial intelligence like generative AI produces is accurate. It just looks accurate most of the time. That's not reliable. And yeah, I think it's an utter shame and honestly pretty dishonest.
Thank you.
Okay, thank you. Just before you go, have we got, Donella, have we got the Logos project queued up?
Yeah, they're ready to go.
Okay, they're ready to go. Okay, we'll just leave it at that, Rimu. Thank you so much for your time and your presentation.
Held up. Thank you.
Thank you. Okay, members, thank you for your patience. I know some of you have got evening commitments and meetings and things, so we'll be soon out of here soon after 5, once we've got our last organisational submission coming through now.
Yeah, not time to tune out yet.
Yeah, no, we've saved the best till last.
That's the one. Good stuff.
Okay, we're in your hands. Welcome.
Kia ora koutou, ko Jen tōku ingoa.
Ko Danielle tōku ingoa.
Ko Sapina tōku ingoa. We represent the Logos project, a Tamaki Makaurau-based Marist youth development organisation and community. Holding strong to our written submission, we strongly oppose this bill. Many have already done an amazing job of articulating why this bill puts the environment at risk, dishonors te tiriti, and prioritises private wealth over collective well-being. Our focus is addressing one of the main points of our submission, that this bill is anti-democratic.
It is anti-democratic because its authors and supporters are relying on and leveraging an anti-democratic process to pass it. We will elaborate on this point shortly, but first we want to give you some insight into who we are, what we stand for, and why we are making this submission. We are addressing the Select Committee, but our message is for the coalition government, and particularly MPs who we hope will be open to changing their mind about passing this bill.
We are making this submission from Whānau Maria, our Youth Development Centre. Whānau Maria is a whare that welcomes thousands of young people every year. We run retreats, experiences that invite young people to embrace their identity and celebrate their diversity. We foster learning about difference, privilege, history, and context. We encourage young people to think critically, to feel deeply, but also to stop and reflect often. We value storytelling and taking the time to really get to know one another. In this whare, everyone is encouraged and empowered to participate, to ask questions, and to contribute. Sadly, these values are not reflected in all areas of society, least of all in the decision-making rooms of Parliament where they are most needed.
Our mahi is with young people, a group of people who are largely disenfranchised. Plainly, us young people are denied the right to vote. Thus, the ways in which young people can meaningfully leverage our democratic power are limited. I was too young to vote in the last election, yet I'm still impacted by the decisions that this government makes. As young people, we are not encouraged to participate in politics, and our parliamentary system does little to nothing to make politics meaningful or digestible to us. So, unless people take the time to engage with us, we remain powerless.
This leads us to our main point, that the Regulatory Standards Bill is undemocratic. Firstly, the current government agreed to pass this bill during their coalition negotiations, before they had the opportunity to listen to the people speak. Secondly, the consultation process was inadequate. The consultation document was difficult to understand and failed to fully outline the bill's details. The consultation period was shortened and conflicted with the summer holidays. They were also trying to distract us with the Treaty Principles Bill at the time. Finally, the Select Committee process has been rushed, giving the public less time to meaningfully engage with this bill. All of this amounts to bad faith politics and undermines meaningful democracy. Instead of engaging meaningfully with experts who oppose this bill, the author has dismissed the evidence they have presented by publicly mocking them, dehumanizing them by calling them bots, and accusing them of spreading misinformation. David Seymour claims that the opponents of this bill simply misunderstand it. As pessimistic as this view is, there is an element of truth to this.
Many of us, and particularly young people, are not experts in law, or the economy, or regulation. Thus, there is a lot we don't understand about this bill. Instead of properly consulting the public, the coalition government is exploiting the lack of public knowledge. Supporters of this bill maintain efforts to keep the public misinformed, but opposition to it has made real efforts to engage us. Everything we understand about this bill, we understand because people took the time to break it down for us. These efforts include countless paid and unpaid hours of TikToks, seminars, workshops, hui, submission, writing parties, and this has come from people with diverse political perspectives and interests. They have explained how this bill impacts people and the planet in different ways. The reason so many people have shown up to oppose this bill is that the experts who oppose this bill have included us in the discussions. They have done their best to make a relatively complex piece of legislation not only understandable, but meaningful to us.
So here's what we understand about this bill, thanks to these experts, not to the government. This bill is of constitutional significance. It contains the missing piece from a suite of neoliberal legislation passed in the 80s and 90s. Legislation that amounts to what Jane Kelsey has described as an economic constitution. The introduction of neoliberal legislation in the 18s represented a major shift in our economic constitution. We moved away from a welfare economy that protected collective well-being towards a deregulated and privatized economy that continues to widen the gap between the rich and the poor. All of these decisions were made before I was born, before I had a voice, and they have had a devastating impact on the crisis economy that my generation has inherited. Thanks to experts like Jane Kelsey, Tania Waikato, Melanie Nelson, and Tina Ngata, just to name a few, We understand that the Regulatory Standards Bill is informed by the same libertarian values and ideology that drove the economic constitutional changes of the 80s. This bill will change the way that we regulate the economy in this country. We understand this, but many of our young people don't. The information is not made accessible to them. This is a constitutional matter, yet it is being rushed through with limited public consultation and no meaningful consultation with young people who have to live longer with the impacts of this decision. I wish that there had been more people in my parents' generation to advocate for my future when the neoliberal reforms were made.
Constitutional transformation is necessary, but it doesn't have to happen this way. Before closing, we'd like to point to another, more democratic political method. One that champions the values of inclusion, storytelling, and taking the time to engage meaningfully with all members of society, with special attention paid to young people.
Mātiki Mai Aotearoa is a movement of people dedicated to constitutional transformation. Their kaupapa is to change our constitution in a way that honours he whakaputanga and te tiriti o Waitangi. In recognition that Māori never ceded sovereignty, one of the aims of Mātiki Mai is to enshrine in our constitution the right for Māori to govern themselves in relationship with the Crown. But the aims of Mātiki Mai are not our primary concern right now. Instead, we want to focus on their methods.
So unlike the coalition government, the leaders of Mātiki Mai recognise what a monumental thing it is to change the constitution. To support their kaupapa of constitutional transformation, they gave themselves over 25 years to accomplish their aims. This has included an initial tour of the country, which facilitated 252 in-person hui, and then years and years of public consultation and education. There was a particular focus on involving rangatahi in these conversations, led by Veronica Tawhai. Since 2010, when Mātiki Mai was inaugurated, thousands and thousands of people, and especially young people, have had the opportunity to learn about the Constitution, what it is, what constitutional law is, and to consider what values they want to see reflected in the Constitution. And this has come from a wide sector of New Zealand and not just one kind of political ideology. During all these hui, feedback from participants was recorded and used to inform the aims of Mātiki Mai. This is the level of political engagement and inclusion that we deserve and that young people deserve. It might take time, but it means you bring everyone with you. The process by which this bill has been introduced to Parliament has fallen far short of this. We urge the government to abandon this bill and to reconsider their approach when it comes to making decisions of constitutional importance.
In conclusion, we want to stress that in the process of passing this bill, the coalition government has done nothing to encourage democratic participation. But do you know who has? All those educators who have dedicated the last few months of their lives educating people across multiple platforms, breaking down different elements of this bill so that we can all understand. And they have had to do it in a very limited time frame. Yet they managed to mobilize close to 100,000 people. Imagine what we could do with 3 years.
Young people don't stay young forever. A new election year is upon us, and we are coming for your vote.
Kia ora.
Kia ora koutou.
Okay. Oh, very good. Well presented. Thank you so much. Now, I've been telling Dr. Duncan Webb he needs to get on TikTok, and you've provided even more evidence for him.
Go, Dr. Duncan.
TikTok videos, Duncan. So Duncan's got a question, and then we'll wind it up. Thank you.
Kia ora, Cameron. You can follow me on TikTok already. Thank you very much.
Oh, he's on there already.
Is that a threat or a promise?
Hey, I just wanted really to give your two rangatahi there an opportunity, because this bill purports to put forward principles of good law, and you've talked about, you being the future and not being young forever. But what might you say would be the touchstone for good lawmaking for you?
Do you want to answer, or shall I?
For me, as rangatahi and as someone who was cut short of a right to vote, like literally by months, a touchstone for me would definitely just being able to voice my opinion and not be denied the right to even be a part of that conversation. So that for me is the most important part.
Just picking up off what Sabina has said, I think the main point of our kōrero is that we just want political conversations to be made more accessible to a wide range of New Zealanders. They kind of get kept in a lot of weight, and I think it's totally possible, and groups like Mātaki Mai, and some of the political parties, actually, the Green Party among them, and Te Pāti Māori, have really shown that you can have conversations on the ground, and that young people are quite interested. And last week, I think, during the holidays, there was this group in Whangarei, I think, who did a big day on, I think it was called Everything is Political, and they got heaps of young people to come and they discussed all kinds of things. And I just think young people are interested in these conversations, and we need more opportunities that are not terrifying like the Select Committee to have. Yeah.
Okay.
Yeah. No, kia ora. Thank you for that. Great submission. Really enjoyed it. Kia ora.
Yeah. Well presented, and you didn't look terrified at all. You made it look very easy. So thank you for being our last submitter for the day. Thank you so much, and all the very best with your futures. Members, we'll wind up for today, but we will reconvene at 8:30 tomorrow morning for our 4th day of public hearings on the Regulatory Standards Bill. So thank you so much for your cooperation and your contributions.
Kia ora.